27 at this item, and in court number 12, item 4, same party, same subject matter. So there are an order that both these matters may be listed together, but separately listed. Today it is listed in court number 12 as item 4, another case. In this court, item 27. So I think both the cases should be listed together because parties are same, subject matter are same.
The request of Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petition. Matter is directed to be listed along with
WBC
number
737023, which is listed today at court number 12, item 4.
Let, when the matter reaches, we'll pass the appropriate order.
I have got the other part.
Yes, madam. Yes.
May teacher lord, I beg to mention item number 40. The contempt lordship, the sole respondent was transferred. So I have to file the impeachment petition. Sole respondent was transferred from the sole lordship. I have to file the impeachment petition. So kindly can tweet that.
You have filed the impleadment application?
I will file.
So then file it, then mention it. No.
Matter related to land corporate. Matter. If notices is long been. May I pay for listing the matter after viewing the petition?
Twenty-fourth.
Dr. With the consent of the other side, I beg to mention item number 21. I am praying on behalf of my senior lordship. She has undergone some surgery. So I'm praying for listing the matter after 4 weeks.
At the request of the learned counsel for the petition, the matter said. Yes.
I am being engaged in this case, my lord, in case of Mr. Goswami, who is having some health problem.
Okay.
I have gone through the pleading. There is a question of maintainability raised by the Assam State Assembly. Therefore, I think, my lord, I will first go into the question of that. So, facts are concerned, my lord, nothing complicated. But this hurdle, my lord, I must be making an endeavor to overcome. And, my lord, to...
No, only problem which I am telling you. Today, ACA, there is some problem with the management. See, the land where the ACA is having is a land which has been donated by the state. So if there is any problem with the management or anything dealing with the management, then obviously a writ will lie. There's no quarrel with that proposition. Just for example, the judgment pertaining to Ramakrishna Mission, which although here the single judge out here held it, yes, writ was maintainable. Division bench said no, and later on the Supreme Court said yes, writ was maintainable, taking into account the land in question was duly donated by the government, and as such, writ was maintainable. But here is a case where it is purely a contractual matter between ACA and the petitioners. Under such circumstances, would the writ be maintainable?
That is what, my lord, I will try to, my lord. Ultimately, it will be for your lordship. My lord, there are the SCA as a juristic entity, my lord, same as my lord PCCA. No doubt about that, I think. Therefore, my lord, I will not put forward argument from myself, my lord. I will rather rely on, my lord, various Supreme Court decisions, where, my lord, the PCCA is juristic as a juristic entity, authority, or any other authority, all these things were discussed. I have, my lord, in my limited capacity, found out certain decisions. I am sure your lordship is already aware of this decision, but I will have to repeat for this case. So, number one test is whether the BCCI discharges a public function. Number two
One
is,
thing, my lord, may I point out, I am, my lord, led by my lord, senior counsel Dita. He is in Lake Kottawat. He will come, my lord. So later after the start, for ACA, he will make the sum.
It's okay. Let him start.
Yeah.
I may not even invite your argument if I'm not satisfied.
so the first, my lord, from all these, my lord, bunches of Supreme Court cases, what I find that whether BCCI discharges public function, that is one measuring. And that, secondly, that construction of a stadium or anything appurtenant works are also public function. Definitely, it cannot be said that they are non-public functions by default, for that matter by HA. And then thirdly, that the board or the SCA, my lord, has positive obligation to citizens. My lord, obligation owned by the board exists, and then mandamus cannot be denied. And in other cases also, Supreme Court has also said that, well, it may not be maintainable under Article 32, but since the ambit of Article 226 is wider, it is maintainable. With that, my lord, only, my lord, confined to this proposition. I will, first, my lord, I will cite, this case is cited in the BCCI's affidavit also, that is my
In
lord.
fact, Mr. Barbara, all the points which you are saying, I'm in agreement with you that yes, ACA discharges public functions, but would it include a contractual liability between ACA and a third party out here or the petitioner out here for the purpose of this? Just for example, if you see the judgment pertaining to the beer manufacturers, the question was before the Supreme Court as to whether a writ will lie or not. The Supreme Court says that when the question arises as regards non-compliance of certain statutory laws by a public functionary, then it will be amounting to discharging a public function, and then it would be. But would this, a contractual obligation between A and B, wherein would come within the ambit? Just for example, if there is manipulation of money in the case of construction of a stadium, obviously writ will lie. But in this case, as to whether a writ will lie vis-a-vis a case of contractual duty, that is another aspect.
I'll try to take on that. My lord, I'll, my lord, refer the G-Television's case, my telefilm case. My lord, certain paragraph. Okay. Here, my lord, for the background of the case, G-Telefilm, my lord, the G-Telefilms were in contact with the BCCI for telecasting of various matches. It is also contractual, basically, emerged out of contract. And then there were certain disputes between the parties with regard to the contract, my lord. Lordship will find at, my lord, page 38, page 649, my lord. Page 649.
Yes. Paragraph
38. Paragraph 38, my lord. At 684.
Yes.
Background fact. My lord, as your lordship knows, this is 3-2 judgment. It is by the background fact is narrated by the minority view judgment, but these are the facts. The first petitioner is one of the largest vertically integrated media entertainment groups in India. The board, the second respondent herein is a society registered under the Tamil Nadu Society Registration Act, which is said to be recognized by the Union of India, the Ministry of Youth Affairs and Sport. Third and fourth respondents are president and secretary respectively of the second respondent. Fifth respondent, ESPN Star Sports, known as ESS, is a partnership firm of the United States of America having a branch of it in Singapore. The sixth respondent is a firm of chartered accountants which was engaged by the board in relation to tender floated on 7/8/2004. Pursuant to or in furtherance of a notice inviting tender for grant of exclusive television rights for the period of 4 years, several entertainment groups, including petitioner and the fifth respondent hearing, gave their offer. Posing here for a minute, in my case, it was pursuant to some NIT floated by the FTA for construction of the various stands of the and pertinent things of the area. We submitted and being successful, my lord, we were given the work order and completed, and then payment was not given. Admitted the those portions of the payment for which a read lies normal. It's actually not complicated. Pursuant to our tender floated on 7/8/2004. Pursuant to or in furtherance of a notice inviting tender for grant of exclusive television rights for a period of 4 years, several entertainment groups, including petitioners and fifth respondent hearing, gave their offer. For the purpose of this matter, we presume that both the petitioners and the respondent were found eligible there. First petitioner gave an offer of amount so and so, or US dollar so and so. Upon holding negotiation, this is the fact, and then this plotted may come to paragraph 40. The fifth respondent, in the meanwhile, filed a writ petition before the Bombay High Court, which was marked as writ petition so and so. Parties there to file their affidavit, state proceedings. In this affidavit, board justified its action in granting the contract in favor of first petitioner. The matter was taken up for hearing on day-to-day basis. Arguments of fifth respondent as also the first respondent had been advanced on so and so date. However, the board, before commencing argument, stated it purportedly have cancelled the entire tender process on the premise that no concluded contract was reached between parties. The first petitioner, it is between the parties. However, before commencing argument, it stated paper to cancel entire process. But as no letter of intent had therefore been issued. Here, my lord, in our case, it is different. We completed our construction work. And then the airport terminated the contract of ESPN and its right. Next paragraph. This is the impugn order which was terminated. Then, my lord, 41, order of the board dated so and so terminating the contract is in question. In this writ petition, contending that the action on part of the board in terminating the contract is arbitrary and thus violative of Article 14 of the Constitution of India. The arbitrary question is there. In the writ petition, petitioners have entirely prayed for setting aside the state communication, as also for issuance of a writ or in the nature of mandamus, commanding the board to act in terms of decision arrived on. So these are the facts, my lord. Then I take your lordship to paragraph 31.
Yeah.
After discussing, my lord, some certain things into 29, 30, I will, it's long, my lord, I will need not take your lordship to straightway, my lord, 31. Be that as it may, it is par majority. Be that as it may, it cannot be denied that board does discharge some duties like the selection of an Indian cricket team, controlling the activities of the player and others involved in the game of cricket. These activities can be said to be akin to public duties and or state functions, and if there is any violation of any constitutional statutory obligation or rights for other citizens, the aggrieved party may not have relief by way of a petition under Article 32. But that does not mean that the violator of such right would go scot-free merely because it or he is not a state. Under the Indian jurisprudence, there is always a just remedy for the violation of the right of a citizen. Though the remedy under 32 is not available, an aggrieved party can always seek a remedy under the ordinary course of law or by way of a writ under 226 of the Constitution. Here, my lord, with all my humility, I am saying, my lord, in my paragraph, writ petition, my lord, paragraph 21, I have stated that they have acted, my lord, arbitrarily, not only arbitrarily, they have denied, my lord, my right of trade and business and my livelihood. My lord, I incurred a huge loss of loan from the bank and all. They have issued, my lord, notice. In fact, they have now started the surface procedure. So, in the petition of my right, my lord. Then 32. In this court, in the case of Andy Mukta, I will refer to this case later on, my lord. This is a case of 1989. After quoted, Article 226 conferred wide powers on High Court to issue writs in the nature of prerogative. This is a striking departure from the English law. Under Article 226, writs can be issued to any person or authority. The term authority used in the context must receive a liberal meaning, like the term of Article 12, which is relevant only for the purpose of enforcement of fundamental rights under Article 32. Now, Article 226 confers powers on the High Court to issue writs for enforcement of fundamental rights as well as non-fundamental. The words any person or authority used in 226 are therefore not to be confined only to statutory authorities or instrumentalities of the state. I highlight, my lord. The form of the body concerned is not very much relevant. What is relevant is the nature of the duty imposed on the body. The duty must be judged in the light of positive obligation owned by the person or authority to effect party, no matter by what means the duty is imposed. If a positive obligation exists, mandamus cannot be denied. In my case, my lord, for works allotted by you and done by me and handed over to you, you actually have an obligation to make due payment. Now, my lord, paragraph 137, paragraph 40, 42, I have read, no? 137. So, my lord, basically, what nature of duty you provide, whether the land is given by government or the central government, so that may not preclude the entire proposition. What?
No, that is what I'm saying. When a land is being given, that is what the judgment in Ramakrishna Mission is. The land was given out there for establishment of the Ramakrishna Mission. Now the question arose out there as to whether a writ would be maintainable. In fact, that matter went from Guwahati. The Supreme Court said out there that no, the writ will be maintainable against Ramakrishna Mission, taking into account that the land which was given by the state authorities for the purpose of construction of the hospital and all. And as such, they were bound to provide the fee or whatever maybe it was there. I will give you the citation out here. Judgment
15, I suppose.
was by Justice Chandrachud. Ramakrishna Mission and another versus Kako, Punya and another. It was delivered on 28th of February 2019. Yes. Where is he? Isn't good. Print out like print out. You look no WhatsApp put. Print out, huh? One put. In fact, this also is similarly lined with that judgment of Justice Arun Mishra pertaining to the Mulchand Trust. There also the question arose out here whether a writ will lie against them or whether they were supposed to give free treatment out there, because the question arose out there, this is absolutely a trust which had nothing to do. But the Supreme Court said, no, you have taken this particular land. Now, in this case also, ACA's land was donated by the state government. So under such circumstances, there might be some similarity to the facts.
My lord, even if it is not an instrumentality or authority, my lord, as Article 12, like Ramakrishna, I think the HCA also obtained the land free from the state government. Not that supports me. On top of that, in addition to the land, I will go one step forward and say Suppose the land is not given by state government, SCA purchased on its own. Even then, having been an entity, my lord, discharging public duties, is supposed to act fairly and to preserve the rights of the legal and fundamental rights of the citizens. My limbo argument. That if I'm able to satisfy. My lord.
The only question which is this court is finding difficulty is whether a contractual obligation would come within the ambit of public duties.
I'll come. One place which is also there. This decision, after that, I'll cite another decision from BRPT. That question I don't know to make it. Now, my lord, this very judgment, telefilm, film, paragraph 137, at page 712. The lordships have defined, my lord, public, what are public function and public use. 137. Public law is a term of art with definite legal consequences. And 139. General view, however, is that whatever the state or an instrumentality of the state is involved, it will be regarded as an issue within the meaning of public law, but where individuals are at loggerhead, the remedy therefore has to be resorted to in private law field. Situation, however, changes with the advancement of state function, particularly when it enters in the field of commerce, industry, and business. As a result whereof either private bodies take up public functions or duties, or they are allowed to do. My lord, like, the business means, my lord, contract also includes. Or they are allowed to do so. The distinction has narrowed down, but again, considerably, such a distinction shall exist. Drawing inspiration from the decision of this court as also other courts, it may be safely inferred that when essential governmental functions are placed or allowed to be performed by a private body, they must be held to have undertaken a public duty of power. This squarely applies, my lord, in my reference. Then, my lord, 158 and 159, my lord. Page 716. 158. The power of the High Court to issue a writ begins with a non-obstantive law. It has jurisdiction to issue such writs to any person or authority, including in appropriate cases any government within its territorial jurisdiction, direction, orders, or writ specified therein for the enforcement of any of the rights conferred by Part 3 and for any other purpose. Article 226 confers an extensive jurisdiction on High Court. Otherwise, this court under 32, in the sense that writs issued by it may run to any person or for purposes other than enforcement of rights conferred by Part 3, but having regard to the term authority, which is used both under 226 and 12, we have our own doubts as to whether any distinction in relation thereto can be made. It might not do reference from Rotas in justice. Yes, my lord, I have not got that. 159, my lord. This aspect of the matter has been considered by Andy Mukta. It has been clearly stated that a writ petition would be maintainable against other persons or bodies who perform purpose. Highlight. Who perform purpose. The nature of duty imposed on the body would be highly relevant for the state purpose. Such type of duty must be judged in the light of positive obligation owed by a person or authority to the affected party. Here I am the affected party. Then, my lord, I will take your lordship to another decision. That is for BCCI versus Cricket Association of Bihar. That was the case of 2015. Yeah. Here, my lord, the facts, the leaves are, my lord, paragraph 2 and 3.
Now, in the majority opinion,
Right.
Majority opinion was given by Justice Hegde.
3:2.
And at last, let us read paragraph 35 and 36 of the earlier text.
Yes. 35, my lord.
35 and 36.
35, my lord. Basically, in conclusion, it should be noted that there can be no two views about the fact that the constitution of the country is a living organism, and it is the duty of the courts to interpret the same to fulfill the needs and aspirations of the people depending on the needs of time. It is notified earlier in this judgment that Article 12 in terms of other authorities was introduced at the time of framing constitution with a limited objective of granting judicial review of action of such authorities which are created under a statute and which discharge state functions. However, because of the need of the day, this court in Rajasthan SCB and Sukhdev, noticing the socio-economic policy of the country, thought it fit to expand the definition of term other authorities to include bodies other than state rule board. This development of law by judicial interpretation culminated in the judgment of Pradeep Kumar Biswas. It is to be noted that meantime the socio-economic policy of Government of India has changed. Falco employed. And the state is today distancing itself from commercial activities and concentrating on governments rather than on business. Therefore, the situation prevailing at the time of Sukhdev is not in existence, at least for the time being. Hence, there seems to be no need to further expand the scope of other authorities in Article 12 by judicial interpretation, at least for the time being. It should also be borne in mind that, as noticed above, in a democracy, there is dividing line between state and non-state enterprise, which is distinct, and the judiciary should not be an instrument to erase the state dividing line unless, of course, circumstances of the day require it to do so. Court gives a rider, my lord, Elway. In the above view of the matter, second respondent court cannot be held to be a state. But having said that, for the purpose of Article 12, consequently, writ petition under Article 32 of this is not maintained. And then later on, its court, my lord, the majority view went on to say, in this case, it said that you cannot come under 32.
No, but then also it was held that it was not a state.
Okay.
The board was held to be not a state.
Even then, my lord, later on, my lord said,
But the
Paragraph
judgment
31.
ends, the majority judgment ends at page 36, paragraph 36.
right, my lord. So also, my lord, the paragraph 31 and 32, which I
Then,
already read.
and then kindly come to another paragraph. which is
Yeah,
very relevant.
already read, my lord. 31 and 32. I may read
Kindly
again.
come to paragraph 172.
Yes.
The 171 would be also relevant.
31 and 32, which I read is also the, my lord,
That I read it. Kindly come to paragraph 171 and 172.
drawing the contract, 71. Drawing the contrast between governmental activities which are private and private activities which are governmental. Matthew J. noticed that besides the so-called traditional functions, the modern state operates a multitude of enterprise. What is therefore relevant materially is the nature of the function. 172, in our view, complex problem has to be resolved keeping in view following further steps. When a body, whichever body might, acts as a public authority and has a public duty to perform, when it is bound to protect human rights, that is different. When it regulates a profession or vocation of a citizen, which is otherwise a fundamental right under a statute or its own rule. When it regulates the right of a citizen under Article 19(1)(a) of the Constitution available, general public viewers of the game cricket, when it exercises a de facto or de jure monopoly, here it does, my lord, other than Asia, no one can run official cricket in Assam. When the state outsources its legislative authority, when it has positive obligation of the public. That is also what my lord said. These states are, as such, had not been considered independently in any other decision of this court, which as would have proceeded and determined the knotty issues involved therein on a clean slate. Then going after
Come to
that, my lord,
176.
gave a ultimately conclusion. It gave, having observed that you cannot come under Article 12 against BCC, Article 32. You may go, and therefore, my lord, so far as this writ petition filed before the Supreme Court, that was the case. But in this case, if the majority view at the same time observe that, well, it is amenable under 1-226, you can go before the High Court. That is precisely my lord humble submission before you. Now coming to the PR case, that will also give some.
Actually, what had happened, Mr. Barbara, here in this case, one has to understand. At that point of time, G Telefilms was trying to get the contract of, I think it was some IPL or something to that effect, whatever it may be. Now it was given to this ESPN Star Sport or something. Then a writ was filed. This was the writ. And the majority opinion said that to Article 32, you couldn't have that. So that judgment remained as it is. And the decision of the BCCI not to cancel was upheld, was not gone into. Then comes ICL, the Indian Cricket League, where a different set of players were playing out there. And anybody, and there you can't get the question of monopoly out there.
Yeah.
The monopoly out there is, if you have, the BCCI came up with such a thing that those people out there who have joined ICL would not be allowed to play for Indian cricket. Now, therefore, we get the era of the history for the other matter, the 2015.
Now, in the Bihar case, allow me to take your lordship to the Bihar case for a while. Here, my lord, Bihar case, my lord, it takes a paragraph 2 and 3. Okay. This is, my lord, 2015 3 SCC. 268, my lord, your lordship will find a fact, paragraph 2. Paragraph 2. These appeals arise of two successive writ petitions filed in public interest by the Appellate Cricket Association of Bihar before the High Court of Bombay for several writs, including a writ in the nature of mandamus directing BCCI to record its order constituting a probe panel comprising 2 retired judges of Madras High Court to inquire into the allegations of betting and non-spot fixing in the IPL made, among others, against Gurumat Mayappan. The High Court, by its order dated so and so, passed in Cricket Association of Bihar. It was the first case. Granted that relief, but declined a positive reconstitution of the panel. While posing here, the High Court entertained the petition. High Court didn't say that your petition is not maintainable, questioning anything done by the Cricket Association of India, BCCI. Then, my lord, the court went to the fact, and ultimately it is always different when, whether on the factum of the case or the causes, petition is on merit rejected or accepted. First question, as the first hurdle here for me, it is maintained. And I am at various high courts also entertain challenges and actions, causes and actions are not undertaken by. Here is, this is one.
No,
my
Mr.
lord.
Barbara, here is a case, in this case, this was relating to the management.
Whatever may.
For management, I said to you, the management, if there is tomorrow, there is there is something wrong with the ACA, this court under 226 can very well do so.
My lord said, yeah, court didn't say that, well, you are a club. It is your internal matter. Settle it among yourselves or go to the other firm. We are not here. We are not bound. Court didn't say. BCCI. And the question is whether the question is election, non-holding of election, or whether the question is of corruption, or whether the question is of my lord betting and match fixing. Ultimately, High Court, Bombay High Court interpreted, and my lord, the Supreme Court also said, yes, and I am on that. But here, maybe construction of an stadium. Here also corruption charges were for 2000, not only against
But the question of corruption is not the issue out here in these
no,
reports.
yeah, in my perspective,
So that is not the
not right. But in our High Court
judgment.
also intervened and directed, my lord, cases, my lord, individual writ or PIL, my lord, controlling, my lord, giving directions to the, my lord, STA. Then paragraph 3, my lord. Here, granted the relief, but declined possible reconstitution of the panel. High Court granted the relief, but declined reconstitution of the panel. 3. Agreed, BCCI assailed the order passed by High Court. In connected civil appeal of the Cricket Association, BIR has prayed for further and consequential order, which, according to the appellant, could and indeed ought to have been passed by the High Court, entirely for removal of respondent number 2 from the post of President of BCCI and cancellation of franchise favoring Chennai Sports King and Rajasthan Royals for the matches to be conducted in future. So these were the disputes between the parties and the questions raised by Bihar Cricket Association. And then, my lord, here, my lord, the court, what the court said, it detailed been discussed. Paragraph 29 of this case, my lord. Paragraph 29, 279.
Yes.
29. The Court of Control Cricket versus Netaji, also this case. This court had an occasion to consider the role and nature of functions being discharged by. This court held that board's control over the sport of cricket was deep and pervasive, and that it exercised enormous public function, which made it obligatory for the board to follow the doctrine of fairness and good conduct. Board as a jurisdiction. It is quoted from my lord Netaji's case,
That's the minority opinion, paragraph 80 and 81.
paragraph 80 and 81.
Then if you only come to paragraph 30.
Yeah, I'll come. Let us see the public functions, my lord, minority view also said there is no dispute between the majority and the minority. So far as that, the postulation that yes, the board discharges public. 81 also it said, this is Netaji. In law, there cannot be any dispute that having regard to the enormity and power exercised by it, the board is bound to follow the doctrine of fairness and good faith in all its activities, having regard to that it has failed to fulfill the hopes and aspirations of millions. It has a duty to act reasonably. It cannot act arbitrarily, whimsically, and capriciously. This is also a case, my lord, where you invite contractors to work, my lord, even in contract well, and they hand over the work to your satisfaction, and even then you don't pay. Then 30, here, my lord, the failed directly consideration of the court. It is, my lord, detailed discussed. Question whether respondent BCCI is paid within the meaning, paid directly for consideration of this court. By a majority, this court ruled that respondent BCCI not a state. I thought yes, BCCI that go, but ultimately they said that even though it is not a state, in view of the fact that it discharges public function and there it is obligatory, it has got the obligation to act positively, you can go under 220. Then, my lord, paragraph 34, 33,
Paragraph 33 would be relevant.
yes, paragraph 33. Majority. The majority view thus favors the BCCI is amenable to the jurisdiction of the High Court under 226, even when it is not a state. In my case, the rationale underlying that view, if we may say with utmost respect that in the nature of duties and functions which BCCI performs, it is common ground that the respondent board has a complete sway over the game of cricket in this country. It regulates and controls the game to the exclusion of all others. It formulates rules, regulations, norms, standards covering all aspects. Enjoys power of choosing members of national team, umpires, exercises power of disqualifying players, which may at times put an end to the sporting career of a person. Non-payment may put my business career. Crores of rupees with bank loan, my lord, which I have not been able to repay because they have not paid my bill. It spends crores of rupees on building and maintaining infrastructure like stadium. Here the word It is a public duty, my lord. Nature and duties and functions, including, my lord, creation of infrastructure by Asia, building stadium, and running of academies and supporting status. It frames pension schemes and expenditure on coaches, trainees, sales, broadcast, telecast rights, and collects admission fee to venues where matches are played. All these activities are undertaken with the tacit concurrence of the state government and the government of India, who are not only fully aware, this sentence is also very important. May not be led, may be led. In addition to that, the tacit, they get all the pilot right from provided of many things surrounding an international game, one day or T20. But they get the stuff. If I arrange a show, I may not get all this. My lord, the state has not chosen, I'm reading again, state has not chosen to bring any law or taken any other step that would entirely deprive or dilute board's monopoly in the field of cricket. Contrary, the government of India has allowed the board to select the national team, which is then recognized by all concerned and applauded by the entire nation, including at times by the highest of the dignitaries when they win tournaments and bring laurel home. Those distinguished themselves in international area are conferred highest civilian awards like Bharat Ratna, Sachin Tendulkar, Padma Vibhushan, Padma Bhushan, and Padma Shri. Apart from sporting awards instituted by government. Such is the passion for the game in the country that cricketers have been icons by youngsters, middle-aged, and older. Now distant. Any organization or entity that has such pervasive control over the game and its affairs and such powers as can make dreams end up in smoke or come true cannot be said to be undertaking a private act. 34. The functions of the board are clearly public functions which till such time the state intervene to take over the state, remain in the nature of public function, no matter discharged by a society registered under the registry. Suffice it to say that the Constitution not only allows an autonomous private body to discharge functions which it could in law take over or regulate, but even grants its assistance to such a non-government body to undertake such functions, by which very nature of functions of that entity discharging the same is not answerable on the standard generally applicable to judicial review of state action. Our answer to question 1, therefore, is in the negative. Qua, the very first part of affirmative qua, its second PCCI may not be stated under Article 12, but is certainly amenable to Article 20. Yeah. Then
Now, Mr. Bogara, kindly come to this decision which I have given to you. You must have got a copy of it, Ramakrishna Mission.
Joseph is referring to paragraph, my lord.
We come to this judgment, paragraph 29. More recently in KK Saxena
Yes,
versus
yes. That is 2015 case. My lord. I'm reading silently.
29.
I'm reading silently.
Yes.
Problem in my throat also. Yes, my lord, I think. And paragraph 31. My lord, Ramakrishna Mission.
You see paragraph 33, 32 and 33.
Yes, my. In paragraph.
Here, the distinguishing element which has been brought in. Yes, there might be some elements which are there, merely because they exercise public function would not make them an amendment. It would depend whether the exercise which was done was in exercise of which is similar to the sovereign duty.
And my lord, in paragraph 31, this judgment also said character of the organizational public authority is dependent on the circumstances of the case.
Absolutely. Now kindly come to paragraph 33. Thus, contracts of purely private nature would not be subject to jurisdiction merely because of the fact that they have been structured by so and so.
Okay. Saxena was, my lord, in the parlance of industrial dispute.
No, that is what they were saying, that if in a case of industrial dispute, the person is there, he is being thrown out, then obviously he will come, writ will lie out there.
That's what.
That is why in paragraph 35, it held that a division bench was wrong.
Hmm.
And the single judge was right. Mr. Barbara,
Right,
we'll
sir.
take up the matter day after. You go through this properly. Because you see, otherwise, yes, no doubt. If it's tomorrow you are complaining about the ACA management, this court will definitely interfere. You go say anything about the corruption out there in the ACA, this court will definitely interfere under 226. Because they will be then exercising public functions, taking into account the various elements by which they have a monopoly, all these things element. Here the monopoly aspect has also been dealt with out here in paragraph 31. But the question is, it being absolutely a pure question, a pure contractual dispute, would it come within the ambit of 226 for exercising a writ?
My lord,
That is the only question which I am on. On that day also, today also, I'm on this only.
so far as G television's ratio is concerned, my lord, Honorable Chief Justice, Chandrachud, this judgment, my lord, it, my lord, has not overruled the, my lord, postulations of the.
No, it is not. That is why I'm saying a writ will definitely lie. Otherwise, a writ, but they have to be doing public functions.
I think there is.
Just for example, tomorrow, if we just go by fact that these people are also the Indian cricket team is also being selected by them and they are exercising. They are playing for the state, for the country,
My lord, it will.
which should also empower, say, to be a public function. Tomorrow, Virat Kohli, for example, for his restaurant out there, appoint somebody to do some work and he comes up and says that he has not paid me the money and I'll issue a writ.
My lord, certain areas, I believe, even in 226, court cannot interfere, like selection of the team. Suppose some players, some 2 players, some why we are not included in the main 11, will your lordship entertain that? Even against the same decision? Definitely not. Even under, the question.
But if there is a question of corruption there, for which a person has been deprived of, then obviously this court can exercise jurisdiction under
My lord, I will try to
226.
satisfy your lordship that the ambit of 226, question of maintainability is that, does it put the shutters before your lordship under 226 closed? Depending on the matter. whether challenging an election, non-holding of an election, corruption, or building of an stadium, like my case. And whether those sort of contexts, like any other context, state context, my lord, by statutory authority, are, my lord, amenable to judicial review. Court says in many other cases, even disputed questions of fact are, my lord, judicial review. 26. And in that light also, I will try to sub. It is not only the question of corruption, or it is not only the question of, my lord, non-holding of election. If at all, my lord, the shutters is open for me, that yes, if you just
No, you have always the remedy. No, you always have the remedy under the private law.
And one more thing, an obligation. You have an obligation existing that I have shown, my lord. I will try.
And the question of having a duty upon them for which they have, this court has, which they have failed to do, for which this court has to exercise the writ by issuance of a mandamus, would depend on facts,
Yes,
depending on what whether it is so to that effect. But the question out here is at the threshold. Should this court exercise a writ in a bad manner of this type?
This context, right? Thereby, my lord, it does not disqualify itself to be considered a judgment. That will be my line of thought.
That is the only difficulty this court is facing. Once you cross that hurdle, then obviously I'll take it. I'll give you time. We'll have it on Wednesday, on next after 2 days.
There is one more case, APL. That also says, my lord, it covers contractual matters.
Which one?
APL interest. I'll try to show, and APL.
Show me that.
2004. There's a case against, my lord, Export Credit Guarantee Corporation against the company.
This is on the question of disputed questions of fact where the court can very well enter if it is can be done on the basis thereof. There is no quarrel with that proposition.
My lord, it says where perform certain public functions, failure to do so give rise to complaint under article. Back up. Anyway,
This is the matter again on on 5th at the top of the list after the motion matter.
start a motion, man. Start a motion.
Gagawin kita lagi.
Order no steps.
Yes, what do you have to say, madam? In
My,
this case, any instructions?
my lord, that up to that instruction, my lord, we have received instruction at 21, my lord, that investigation was going on, my. So up to that instruction, we have to take.
Instruction investigation is going on. The recent cases of murders in the case of Ganga in Coimbatore.
That during investigation, no direct evidences found established that allegations were for investigation progress. However, the same are under investigation.
So upon investigation, both the cases in it has been found that Jubair Ahmed, who is Jubair Ahmed, is the petitioner.
No, No, my lord. Harun Nessa is the petitioner.
But why is it taking such a long time to get the FSL report?
My lord,
We'll have it on 12th of January. Just get your instruction.
my lord.
List the matter again on 12th of January, on which date Mrs. Udas, the learned additional senior government advocate, shall apprise this court as regards the status pertaining to Badarpur PS case number 307/2020, as well as Badarpur PS case number 315/2020.
And number two,
Why a writ has been filed against these type of orders? Who's appearing? None appears on behalf of the petitioner on call. Further to that, no steps have been taken pursuant to the order dated 2/3/2021, for which the matter has been listed before this court today. It seems that the petitioner is no longer interested in the instant proceedings, for which the instant petition stands dismissed for non-prosecution.
number three,
Here, this step has not been taken by the petitioner. So I may be allowed to take this case as well. Court directed to take press case. on Respondent number 4.
Why haven't you not taken steps? What is this matter about?
The matter is lordship
It
about
pertains to, my lord, settlement of a stall in the North Lakhimpur railway station, my lord. And the stall was settled by way of a tender process.
To refrain from giving effect to the impugned order related demand issued by the deputy minimum to wide effort.
Petitioner has not even participated in the tender process, my lord, and it has been settled with the respondent number 4 by way of a tender process. It doesn't have a cause of action. His claim is that being a local of that area, he should be given preference
Yeah.
in allotment.
petitioner.
There was a tender
Yes, yes.
and the petitioner did not participate. Then on what basis are you challenging it? Show me that.
Being a local, he should be given the settlement. That's the only claim.
You have not taken steps also.
Lordship, today I am appearing on behalf of my
No, nothing doing. You know, this court is very,
Yes, ma'am. Yes.
is not into all these things.
Chancellor.
You have not participated. Next time you participate, this is for how many years you have given it?
4 years.
Another 4 years is about to end. Another 4 years. It's 2024. See, now you better participate. The next tender process. You are using a new tender process.
Lordship, the lordship may kindly see annexure 1, page 14, lordship. This is the page 14, annexure 1.
Hmm.
To the new application for allotment of place for established to of VIP Amul Road.
Hmm.
Reference is upon that the lordship's application addressed to DMNF dated nil forwarded by Sri Pradhan Borua. Lordship applied for the stall lot. Page 14, lordship.
8.
14, annexure 1.
Yes.
Letter dot
Application for allotment of place for establishment of a VIP Amul store. Please find herewith the representation is based upon the for allotment of the place for establishment of VIP store. Okay, then
An application, the petitioner applied for the authority.
no. Tell me whether the respondent number 4 got it on the basis of a tender process.
Yes, yes.
Yes, sir.
Page 23,
Page?
lecture 8. That's the
How do you say LOA for allotment of so and so? This office press notice that in reference it is here informed the NFA accepted your offer for awarding milk stall at so and so subject to the following. How do you say that this is pursuant to the tender process?
Well, this is I've got the instructions, my lord. I've read it the affidavit in opposition also. I've read it the affidavit in opposition also.
Ah,
Therein, my lord, every detail. has
where is
been-
the instruction? Show me the piece of paper.
I'm
I think.
filing.
You have the piece of paper
It's
showing
like-
that the
it's in
tender
my
document.
clerk. Within 10 minutes, I can produce. my lord. I've given it to the clerk to file the affidavit in opposition.
Okay, we'll take it out two.
Okay, okay.
Two.
Oh.
Because you see, and if it is the pursuant to a tender process, nothing remains out there. And you have not interested for the last 4 years, to take steps.
Okay, sir.
You will give the slip.
Matter 4.
Yes. Why you have not taken steps?
Lordship, there was some miscommunication between us and the clerk, Lord,
You have miscommunication with whom?
without clerk, Lord.
With your clerk.
Today itself, we will be taking steps, Lord.
You are challenging an FIR. Why? And 4 FIRs
Lordship, as because multiple FIR was lodged against the single.
against you.
Yes, Lord.
Why?
Lordship, it was the fact was, Lordship, there was a alleged distorted image of goddess Durga, Lordship. It was in publication in a newspaper of Nandini magazine, and
Ah.
it was published on October 2021, Lordship.
Hmm.
So hence, sir, and so, Lordship, a single FIR was lodged on Lamding, Lordship, and after that, multiple FIRs were lodged in some were lodged in uh, Mangal-Doi, Paltan Bazar. So hence,
My lord, now all are amalgamated, my lord, and now, my lord, with the Polton Bazar case number 968 of 21. So now is with my lord Polton Bazar.
So-
police station.
If it is amalgamated, one is over. Fight it out.
4 cases, my lord, registered.
Show
and
me.
taken.
Where is that
My lord,
instruction?
that's my-
The instant writ petition has been filed. Challenging. For setting aside and quashing the 6 first information reports lodged against the petitioners, which are Polton Bazar lodged against the petitioners and thereupon being registered by the respective police stations. The said FIR have been registered as Polton Bazar PS case number 1. Now, case number 968/2021, number to Roman 2. Bokister PS case number 1882/2021, Roman 3. FIR, which one is this? Mongoldo is which one? What is this Mongoldo FIR file before Mongoldo? You don't know the number.
Mongoldo, my lord. There must be in that. Mongoldo PS, Lamding PS case number 205.
Number 1 Dylan, number 2 Dylan, number 3 Dio. FIR lodged before the Mongoldo Sodor police station. Number 4, FIR lodged before the Dispur police station. And FIR, number 6, FIR lodged before the Chanmai police station. In the writ petition, there has been no details furnished as regards the FIRs filed in Mongoldo Sodor police station, Dispur police station, and Chanmai police station. Next, be that as it may, upon notice being issued, Mrs. Yuda, the learned additional senior government advocate, has produced an instruction to the effect that Chanmari PS case number 663/2021 was registered on being transferred to our Dispur PS case number 3675/2021. Thereupon, the officer in charge of Chanmari PS case police station submitted a prayer to the court to transfer the case to Polton Bazar PS, as the offense as mentioned in the FIR is of the same nature. Accordingly, an order was passed by the court below for transferring the said Chanmari PS, the Chanmari PS case number 663/2021 to Polton Bazar PS police station and registered as Polton Bazar PS case number 1035/2021. Similarly, Okisto PS case number 1882/2021 was transferred to Polton Bazar police station as per an order passed by the learned court below, and it has been again re-registered as Polton Bazar PS case number 1038/2021. The Ajia PS case number, AGIA PS case number 149/2021 of Gwalpara district was transferred to Chanmai police station, and the same, upon being forwarded, was re-registered as Polton Bazar PS case number 1153/2021 on the orders passed by the learned court below. The Lamding police case number 205/2021 was also transferred to Chanmai police station, and the OC of the officer in charge of the Chanmari police station forwarded the case to the Polton Bazar PS, and accordingly the case has been re-registered as Polton Bazar PS case number 1154/2021. Thereupon, all these 4 cases were amalgamated with Polton Bazar PS case number 968/2021. Under such circumstances, as the said FIR has been, as all these cases have been amalgamated, as has been informed to this court by the instructions dated 8/12/2021. This court finds no reason for issuance of any writ in the instant case. Accordingly, the writ petition stands closed on the above observation. The instructions were placed by Mrs. Yudas, the additional senior government advocate, is kept on record and marked with the letter X.
Okay.
So you save your money taking unnecessary steps. Right, Peter?
Five,
May I please your lordship?
Hmm.
This case has become infructuous.
Infructuous. Mr. F.U. Borbuya, the learned counsel appearing on behalf of the petitioner, submits that the writ petition has become infructuous. Accordingly, the writ petition stands closed closed as it has become infructuous. The interim order passed on 13/12/2021 accordingly stands vacated.
Obliged.
number 6 for admission.
My lord, in this case, my lord, respondent insurance company took time, deputed it, filed application of and matter has come today for admission. Whether they will file affidavit or not.
Lord, your lordship will see that whether this is maintainable at all.
What is this matter? Challenging?
Challenging the, my lord, the rejection of the claim of the petitioner, my lord, on the ground that, my lord, the policy stood repudiated by the insurance company because it doesn't have any insurance interest. My lord, I am the registered owner of a vehicle. Sorry, my lord, my husband is the registered owner of the vehicle. Ultimately, he died during the validity period of the insurance policy. Then, my lord,
He retired,
no, he expired.
expired.
Then, my lord, I approached the insurance company and policy was renewed. At that point of time, my lord, I approached the, my lord, district authority to transfer the RC book as well as, my lord, transfer the policy of the insurance, transfer the insurance policy. Then they took the plea that unless and until RC book is registered, we are not in a position to transfer. And, my lord, in the event of lapse of the, my lord, insurance policy, I offered, my lord, premium. They accepted the premium.
They
We should have-
accepted the premium.
Premium in the name of course, in the name of the dead person. Then, my lord, vehicle was stolen, and I lost an affair. Police investigation was, my lord, going on. They could not come to any conclusion regarding the, my lord, vehicle, whether it is stressed out or not. Then I approached the CGM. CGM issued a direction to complete the investigation and submit the report. In the meantime, my lord, I again approached the insurance company. Insurance company says unless and until death certificate is issued and you can produce the death certificate, question does not arise to transfer the policy. My lord, Register of Death and Birth Authority, they kept the matter pending. Under such compelling circumstances, I had to approve the deputy committee. Deputy committee issued a direction to issue the death certificate. Then I, my lord, obtained the death certificate, and at the same time, direction was given to complete the investigation. They completed the investigation, submitted the FR, saying that vehicle is not stressed out. Then I approached the insurance company. They asked me to submit your claim petition. I submitted the claim petition along with all testimony. They kept the matter pending. Then I approached the matter under such compelling circumstances, insurance ombudsman. Day on which I approached the insurance ombudsman, I received a letter at 2 p.m. that my insurance claim is, my lord, rejected by them on the ground of, my lord, that there is a lapse on my part in not disclosing the real facts
there is a separation of material facts. Then Ombudsman Authority, my lord, they issued a notice asking me to submit my document. I submitted. Notice was issued to insurance company. Produce the relevant record. They did not appear. They just submitted certain documents, and on the latter date, my lord, subsequently, the Ombudsman came to the conclusion that there is nothing to interfere with the decision of the insurance company. So under such circumstances, my lord, I approve this now. Therefore, my lord, there are some
So
factors.
your issue is, if I may, in a nutshell put it,
My lord.
your husband owned a vehicle.
Fine.
During the period, the insurance was there in respect to the vehicle.
Yes.
Your husband expired.
Fine.
You intimated them about that.
Fine.
And after intimated you again upon the expiry also,
Fine.
you have also paid the premium,
Fine.
which they accepted it
Fine.
in the name of the husband.
Husband.
And then now they say that, look here, you have not intimated all these facts,
Fine.
and as such, your insurance is invalid.
Fine.
On the ground that this is an insurance policy, there is a term out there wherein it is stated out there that
Yes.
if there is not a proper disclosure of the facts,
Yes.
then it will be reputed.
Exactly.
That's your case.
Now, my lord, affidavit is certainly necessary because there are some factual aspects they did not controvert. They said I didn't.
So the moment
said
you
I-
say about factual aspects out there, why the district consumer forum is not the right forum? I'm coming in 5 minutes.
Sort of evidence. So, my lord, if I say that, my lord, lordship may be kind enough to transfer the matter to appropriate consumer forum. Otherwise, my
Consumer
lord,
forum, you have to go there.
They can approach me.
otherwise, my lord, they said that they are two different standard, different point of time. Sometimes they are saying there's a delay on our part.
Because you have to prove that aspect.
Yeah.
I will do one thing. I will dismiss it. No. The reason I have to dismiss it on the question of jurisdiction.
No,
And
no,
then, no, kindly listen, mister.
Right.
I'll dismiss it on the question of jurisdiction, on the question of factual aspects being there. And thereby give you that limitation period you have to take care of. Na? If I allow you to withdraw, then you would not get the benefit of limitation
Right,
under
right,
14.
right.
So I have to hold it that on the bed, you have been bona fidely and diligently fighting the matter out here.
That observation, my lord. may
And
be-
that is why, if you withdraw it,
Right.
I can't give it to you.
Right.
The instant writ petition has been filed by the petitioner, being aggrieved by the repudiation on the repudiation of the insurance. Insurance claim, as well as the judgment and order dated 10/9/2013 passed by the learned insurance ombudsman in complaint case number 11-GI-G1-076/12-13, and also seeking a direction upon the respondent insurance company to pay the said amount of the claim made by the petition. Upon hearing the matter at length, it transpired that there are various factual aspects which requires to be adjudicated upon. And these aspects cannot be adjudicated under Article 2 to 6 of the Constitution, taking into account that it would require examination, it would require looking into various intrinsic aspects pertaining to evidence, intrinsic aspects as regards the evidence. It would be therefore, the petitioner therefore would be well advised to approach the appropriate forum before which the petitioner can, wherein the factual aspects could be determined. So taking into account the above, this court is not inclined to entertain the instant writ petition. Be that as it may, taking into account that the petitioner has been bona fidely pursuing the instant writ proceedings since 21/5/2015 till date. The period during which the period from 21/5/2015 till date shall be excluded while computing the period of limitation in preferring such proceedings as available under law.
Much obliged.
And may I, may I, my lord, request your lordship, can you give us some time frame, otherwise time frame? In that period, my lord, endeavor made for disposal of that.
Mr. Pukas, you have not yet filed. Without the baby being born, you want that the baby should be an engineer?
Lordship has, my lord, long hand to that.
Item 7.
In this manner, nothing survives your lordship. Because the period was 7 years, your lordship. The settlement period was for 7 years. If from 2017 to 2027 is already has gone, your lordship.
None appears on behalf of the petitioner on call. It also is Mr. R. Gogoi, the learned counsel appearing on behalf of the
Forest Department.
Forest Department submits that the settlement period is already over. So taking into account the above, the instant writ petition is already over. The learned counsel further submits that the instant writ petition accordingly has become infructuous. Taking into account the above, the instant writ petition stands closed as it has become infructuous.
Obliged, Lord.
Please, my lord.
Yes, madam, what is this matter about?
We have challenged the order dated,
More private.
order passed by the Assam Human Rights Commission.
Why?
Is without jurisdiction because it has gone into a subject which was not within it.
Where is the order?
The impugned order, your lord will find at page 33, 9, 11, 15.
D. 3.
33. D1. Second paragraph, if I may read.
Yes.
Husband, Sri Pranab Kumar Das, being a cancer patient treated by Dr. B.K. Das at Purva Cancer Institute, Guwahati, where some tests were also done at the advice of the doctor, but the doctor advised the patient for operation, clean operation at Kumar Nursing Home, Borodomo, Kumarpura, Guwahati. Although the family of the patient wanted the later to be operated upon at the state cancer, the operation was accordingly performed on 5/12/2011 at 5 p.m. at the state nursing home. Dr. B.K. Das and the anesthesiologist, one Dr. Hussain, informed the members of the family of Pranab Das at about 7:30 p.m. the same day that the operation was successful and the patient was normal. But it was at about 9:30 p.m. that Dr. B.K. Das advised the patient to be shifted to Dispur Hospital for ICU facilities not being available at Kumar Nursing. Although the family of the patient wanted to shift him to CMCH, Dr. Das himself called an ambulance and referred the patient to Dispur Hospital, where he was admitted to the ICU at night. The doctors of Dispur Hospital treated Pranab Das at the state hospital for 2 months and 10 days in the ICU, whereafter he was referred to GMCH on 5/2/2012. The patient has since been under treatment at GMCH. The two doctors, Dr. K. Das and Dr. Hussain, offered 15,000 being compensatory for wrong treatment of the patient at Dispur Hospital, but the family members did not accept it. When it comes to this, my lord, the impugned recommendation, which is at page 41, para 26. Accordingly, the Assam Human Rights Commission directed para 26 method, it is
Hmm.
therefore recommended that to the government of Assam in Department of Health and Family Welfare to initiate disciplinary proceedings in accordance with law for taking appropriate action thereunder against Ikedas and pay compensation of 5 lakh to the complainant, Srimati Orchana Das, the wife of the deceased, Pranab Kumar Das, for realizing the entire amount as compensation from Dr. K. Das, son of late so-and-so, presently serving as Surgical Oncology Department of the Purva Cancer Institute, Guwahati, through the Secretary Health Service. These were the impugn recommendations, Lordship. Firstly, my lord,
You are concerned with number 1 and number 2, A and B.
Lordship, I am for the petition.
Understood. You are worried with A and B, not C and D.
If I may further take your lordship to page 38, there is a specific finding that since Dr. A. Hussain is not found to be a public servant, not being a government doctor, his such default in not responding to the state notice issued to him had been ignored. If my lord, the state Dr. A. Hussain is not a public servant, even I was not a public servant at that point of time, because I was working at Purva Cancer. It is an autonomous body, lordship. It was set up by a voluntary organization called Dr. Purva Cancer Society Trust and was recognized as a regional cancer center by the Ministry of Health and Family Welfare. In 1980, it was set up, lordship.
What did the inquiry report say?
It had, I have annexed it in the an additional affidavit.
What does it say? Who was the inquiry officer? Joint Director.
Join that. Page 7, lordship. Inquiry report in respect of Sri Pranab Kumar Das regarding Assam Human Rights Commission case number.
You are referring to page 73, running page 73. Of that is the inquiry report
Yes,
which have been brought
yes,
in
Lord.
by way of an additional affidavit.
Yes. Fourth para, lordship. According to the statement of Dr. Bhavesh Kumar Das, Sri Pranab Kumar Das, along with his relatives, approached Dr. Bhavesh Kumar Das at the Kumar Nursing Home in the later part of November 2011 for surgical opinion, which was advised by Dr. Sidananda Das Bhuyan, Professor and Head of the Department of Medical Oncology Department, Purva Cancer Institute. It is as per the desire of the patient and his relatives, it was decided to carry out the surgical procedure at Kumar Nursing Home, and accordingly he was admitted on 5/12/2012 at 7:30 a.m. at Kumar Nursing Home and decided to carry on out the surgical procedure at Kumar Nursing Home after adequate and proper operative evaluation of the patient. Thereafter, lordship, the third paragraph from there. According to the statement of Dr. Yadav Kumar, proprietor of Kumar Nursing Home, Sri Pranab Kumar Das was admitted to the hospital at on 5/12/2012 at 7:30 a.m. with indoor registration number so and so, as per advice of Dr. Bhavesh Kumar Das, and fixed operation on 5 p.m. at 5 p.m. on 5/12/2011. At the time of operation, Sri Yadav Kumar Das was away from the hospital, and around 9 p.m., Dr. B.K. Das and Dr. Akbar Hussain informed him about the condition of the patient, and he advised the concerned doctors to shift the patient to a well-equipped hospital where all facilities were available, as there is no facility of ICU at his nursing home.
No, which is the inquiry report which tells you that you were responsible?
Inquiry report has not made any specific finding against it. However, it
If
is
there is nothing out there, how could the Assam Human Rights Commission come to a finding to that?
lordship.
Your lordship, it's at remarks, the remarks
Where?
at the penultimate page, your lordship.
It is by the Deputy Secretary to Government of Assam,
The
Health and
committee,
Family.
your lordship, there were 4 doctors. There were 4 doctors who conducted the inquiry. One was the head of the Department of Anesthesia, one was the head of the Department of Surgery, one was Jodunath Borgoy, who was the assistant professor at that moment of time. He was an oncological surgeon. So he was also there in that committee. And one from the medicine department. These 4 people conducted the inquiry, your lordship. And the remarks were that there was no proper ICU facilities in the Kumar nursing home, wherein they have conducted the surgery. And most importantly, your lordship, no documents were maintained by the hospital authorities or these doctors. And as on date, your lordship, no documents have been
No,
handed over.
was Mr. Bikedas, huh?
Yes, your lordship.
Was he a visiting surgeon or a surgeon out there?
He was a person who was employed at BBCI, and he was also a visiting surgeon at Kumar
So,
nursing home.
so how can he have any say on what are the documents to be maintained? It is for the Kumar nursing home to say it. Right? Just for example, tomorrow in downtown hospital, a person comes out there. He has no say out there as regards to what the management of downtown hospital would be doing. He's just a visiting surgeon. How can there be imposition of 5 lakhs upon him? Yes, imposition on Kumar nursing home, if it is done, it is a different aspect on these remarks. But can it be done upon that person concerned? That is one. The second is as regards disciplinary inquiry against him. Why?
Because he was an employee, your lordship, of the BBCI, your lordship,
So?
which is well within the control of the lordship. What happened, your lordship? Let me just explain the facts. In fact, your lordship, when I went to consult at the BBCI first, I was told to consult these 2 doctors because they are surgeons. I consulted them. They said that we will not operate here. We will operate at Kumar nursing home. So as per their advice, we went there for the operation. But after and pre and post operation, no documents were given to us. lordship. Neither doctors, even we asked from the doctors said, no, we didn't maintain any record. And when the patient was shifted to
The documents, who is going to give it to you? The Kumar nursing home at best. You went to that hospital. It is they who are burdened, the duty bound to do that.
but that was not done, your lord.
So
And,
that
and
is
most
what-
importantly,
And in fact, I am surprised why you are there before the Assam Human Rights Commission. Why not before the Consumer Forum?
your lordship, because with
Because you see the judgment in Jacob Matthew makes it very clear out there not to take up any action against these persons unless you have this particular inquiry report to the effect. So the inquiry report has to categorically hold, yes, these people were responsible.
yes, that's what this inquiry report holds. Because your lordship, in spite of there being not proper ICU facilities, why they operated the patient out there? Your lord, that is the categorical finding, your lordship.
So
with the
then if that is so, then wouldn't it be proper for the Kumar nursing home to be imposed with it?
But the doctors are also responsible. They should not have operated.
No,
Spleen-
can the human rights, you see, there is a very important thing. Can the human rights or the commission decide on the question of the factum of facts out there
Yes,
where it is not true? Whether this person concerned had said, entirely go from BCHI to Kumar Narsingh. Did he say that? This is a question of fact. Then how can these aspects of the matter be at best taken into account by the Assam Human Rights Commission?
your lordship, in the inquiry report, they have categorically stated that the operation was performed. There not been proper facilities. There was no
Understood.
proper
Let
ICU.
it be. Operation was performed. They have gone out there. They have performed the operation. Who has done it? It is the Kumar Nursing Home who has done it, not the other people.
Your lordship, I was the patient. Initially, I went to the BBCI.
Very well.
The doctor said me, you do there. I went there. if there was no proper ICU facilities, they should not have conducted the operation there. The doctor should not have conducted the operation there. So whether
No,
it was
the
not,
fact as to whether you have gone out there at the advice of Pikeda is a question of fact where it has to be proved somewhere. Where is it? It is the finding out there, right? That yes, from these evidence, he was the person who asked you to go there. Where is that? If that is not there, how can the court could have authorities could have come to that finding? Isn't that your case?
Yes, my lord. And moreover,
Or am I making you okay? Tell me how? Yes, these aspects could have been very well taken care of by the district or the state consumer forum. You could have gotten more money for this, 5 lakhs. But the fact that these persons concerned have advised these people to go from there, how could some human rights commission come to a finding unless there is some categorical findings to be arrived at that this person concerned has asked this person not to do it out there in BCCI to go there? And where is your affidavit?
Your Lordship, I have not filed any affidavit, Your
Then?
Lordship.
You thought that it was not necessary. on
No, the
basis of
reason is
fact.
that, Your Lordship, this lady has met with an accident and she is bedridden. She could not came to me. I contacted her yesterday, Your Lordship.
You contacted her yesterday of a 2015 matter.
No, Your Lordship, in 2020, she came to me.
And then
Thereafter, she met with an accident, Your Lordship, and
Ah.
she was bedridden for almost 2.5 years. And she has a minor girl to take care of. She told me that there are some documents which are, this patient was taken to Chennai thereafter, wherein a report was there that he didn't have cancer, which was told,
understood. These are all questions which needs to be adjudicated by a district consumer forum or a state
Your
consumer
Lordship,
forum.
there
What is
are-
this human rights business doing all this? Or human rights didn't have any case, so they have taken up this
no, Your
matter.
Lordship, the issue is that human rights can take up this case because he is a public servant. The main case is that they have raised a maintainability issue that this person,
Human rights is not always in vis-a-vis the public servant or not. It can be even against the private
Exactly, Your
person. Also.
Lordship.
There's no quarrel with that position. I'm not that. But when it is a question of facts to be decided, wouldn't that be the proper forums of the district and the sayers there? When we get to when the judgment is there of Jacob Matthews and all. Because all these documents do not in any manner suggest that this person concerned he was a visiting surgeon. He must have gone out there. Yes, he is not responsible thereafter. He is only due to did he take any fees from you for any other purpose out there? No. His surgery fees was only limited to what he has done.
but there is a finding categorically that they have on their own shifted this patient, these doctors have shifted this patient to Dispur Hospital.
Absolutely. So they have when they saw that this is not possible out there to do, so they have obviously sent it in the right earnest. If that is being done at the right earnest, are you going to blame them?
Your Lordship, that has never been done by a doctor. The fact is that they have done it because they have realized what they have done. And things went out of control. The patient went immediately to coma. That was also not informed, Your Lordship. Everything is there.
All these aspects, I have used sympathy for the patient out there or the family out there. But the fact is this the right forum? Yes, there were many other cases out there for all these things. Unless there is something categorical to the effect that yes, this person advised. Now today, something happens out there and a person GMCH may not be providing you may not have this is of 2011.
11.
At that point of time, Dispur Hospital or even the other hospitals may have better opportunities out there. With the GMCH, there may be dearth of beds. Yes, health. What do you say? You are there? You are the health?
Yes, Lord.
Health is a part.
Yes, Lord.
Yes. What do you have to say?
Lordship, we have only acted as per the human rights, but order law.
That you have acted, it's a different thing. I'm not on that.
And Lordship.
But
at
what do you
present,
have to say out here? Now, there might be a case that is it necessary that a person has to, a doctor who looked into out here and finds that it is absolutely subjective on his, can't be objective. It is to be his subjective satisfaction. That he thinks, yes, this hospital may be giving them a better treatment. Or any private nursing home, if they find any difficulty out there, are they bound to refer only to KMCH?
No. Moreover, Lordship, now this institute is handled by the government of India, Lordship. So we do not give any grant in it, Lordship.
You do not give?
Any grant in it, Lordship. Now the government doesn't look into the T-Board Cancer Institute, Lordship. It is handled by the Department of Atomic Energy.
No, that is okay. That is okay. But whatever may be, there is a stigma attached to what the petitioners have done. Because without a finding of fact arrived at category, yes, he was responsible. For him, he went to BBCI, and thereupon he insisted, finally go to Kumar Nursing Home. Then only I'll operate. These are questions of fact. How can the Assam Human Rights Commission decide on these unless they have the power to take evidence? If they have taken the evidence, they should have. But even if the inquiry report also do not suggest that it was done so, does it? The facts may be really appalling out there, but does it mean that the Human Rights Commission will pass such orders? Yes, Mr. Sinha.
Lordship,
He is not
only-
supporting you. Yes.
Only there was a finding by the inquiry committee that there was no specialist anesthesia in that hospital. There was no technician, there was no facilities available. This was known to those doctors.
Is there a finding?
Yes.
That no, is there a finding?
Yes.
That you went out there at your own volition, or did you go out there at the suggestion?
There is nothing to
Without that, how can you? Tell me how. Give me a good reason how. Without that finding, the fulcrum of this entire case is gone. The judgment is fulcrum of the judgment doesn't remain. That is the only finding you require. Yes, you have for whom?
And
Who 7? Yes.
Whether the finding is that other patient related work to Dr. Dar in that nursing home for the 30. It is there in that one of the inquiry reports that page 7. That is additional affidavit.
Page 7 where?
According to the statement of Dr. Bhavesh Kumar, the chief Pranab Kumar Das,
No, this is his statement.
Yes.
I'm not on his statement. Where's the finding?
there is no finding.
These are all recording. Where's the finding that they went from this place to that place on the basis of this? You see, what is the punishment? What is the imposition or the penalty imposed? First, they say that disciplinary proceedings be initiated against BK Das. Number 2, say impose 5 lakhs upon Mr. BK Das, Dr. BK Das. Why? There has to be some basis. Unless there is a specific finding to the effect that yes, at his instance he went, then if that is any finding to the effect is there, how could the Assam Human Rights Commission come to that opinion? That's my only question. Yes.
According to the statement of Dr.
Hmm.
Further, if you read this paragraph,
at his hospital area with indoor registration advice as per advice of Dr. Iman and fixed operation of so on Iman. Operation was completed at 7:30 at 9 p.m.
Yes.
Operation was done at what time? Yeah, 7:30 p.m.
Yes.
And was again brought to at 10:40. Now the question is, you see, it is within a very short span of time everything happened. The operation was completed at 7:30. At 10:40, he was admitted. And during this period, if he was put into that ICU facility, would it have made a difference?
Your Lordship, they wanted to shift off their responsibility from the person.
We will look into it whether to shift
Yes.
or not. But would it have made a difference? Because that is the question. If it would have made a difference,
Your
the
Lordship,
immediately after the operation, till the operation was done, it was okay. There was no problem with that because the operation was done. Now, the second aspect is a wrong diagnosis. If it is made, it is again a different aspect of the matter which this court cannot look into it. neither the Assam Human Rights Commission. The only aspect is after 7:30 till 10:40, whether the non-grant giving the proper medical facilities to the patient have led to the death. He died,
Yes.
led to the whatever happened to him and subsequent to the death. No, understood, but
From the date of the operation to till the patient expired, he was under coma.
no, from 7:30 because he was okay. He did not get back his consciousness
Yes.
because obviously he must have been put into some anesthesia out there. It may not be immediately.
No,
He
he
may
was
not.
given twice. He was given twice anesthesia.
But regarding,
I don't know why he was given twice.
I also don't know.
But why he was given twice, that twice he should not, that is the finding of the inquiry committee, which was done by the doctors. That they have said. In fact, your lordships kindly see the internal page 16 of this inquiry report. There is a categorical finding of the inquiry report.
Where?
Number 4.
Page
Internal page 16, your
of which report?
of the additional affidavit filed by my learned friend.
Internal page 16. Yes.
Number 4. This is the finding of the inquiry committee. They said, accordingly, he consulted Dr. Bhavesh Kumar Das, MS surgical oncologist, and Dr. B. Das explained to them about the surgery and told them to get admitted for surgery in Kumar Nursing Home, Kumar.
Who is appearing for the Kumar Nursing Home? Is he a party? Because here may not be a case where imposition of 5 lakhs or this, but this is a pure case as to how medical facilities in a nursing home should be. Because it may not be a case of giving anything out there, or even this court prima facie also on the basis of the inquiry report, imposition of 5 lakhs may not be this court is maybe appropriate. That is not on the issue, but the issue more is to tackle the unwanted, certain medical institutions or cropping up of mushrooming of medical institutions out there having no proper facilities. I don't understand as to how the Kumar Nursing Home, knowing it, even if an outstation or a visiting surgeon advises to do it, how they could have done that without having the proper facilities.
Yes, your
I
lordship.
think we'll make Kumar Nursing Home a party. Then I think we should go ahead.
One more submission I may just make from a personal knowledge, as I had dealt with the patient. In fact, as on date, there is not even a single hospital in Guwahati equipped to perform this spleen operation. I can say, I've seen the operation facilities at other hospitals, what care they require. It's not that easy, your lordship.
No, it's okay. You see, there is, whether this can be done or not, that is not the question out here. The question is, without having proper facilities,
Yes, your lordship.
how is it possible?
Right.
All of you have filed your affidavit? You have filed your affidavit? I don't see any affidavit here. Filed by response number 7. You have not filed, you filed.
Your lordship will give me some time.
Because this is a matter to be taken up, not on the other aspects. You have paid the 5 lakhs?
No,
If
Pay the 5 lakhs, we'll look into it.
interim stay order is there.
Huh?
there is a
We vacate that portion, pay the 5 lakhs. We'll soon look into it. You are doctors, you have got good money. Pay the
Let them
5.
File the affidavit first.
Huh?
Let them file the affidavit.
No, you pay the 5 lakhs. We'll consider as to how to get the 5 lakhs back to you later. But pay the 5 lakhs. He's not in a position out there. What has happened out there? This court, after hearing the learned counsels for the party, is of the opinion that the dispute which has a reason for consideration in view of the order passed by the, in view of the order dated 9/11/2015 passed by the Assam Human Rights Commission, Guwahati, in AHRC case number 1/26/11-12. The Kumar Nursing Home, wherein the patient, late Pranab Kumar Das, was admitted, and the operation was conducted, is required to be made a necessary party to the incident proceedings. Accordingly, this court impledes Dr. Jadab Kumar, proprietor of Kumar Nursing Home, having its principal place of business at where?
at Bharlamukh. Your lordship, may I just
At Bharlamukh. How Bharlamukh, it won't go there.
Kumar
Kumarpada.
At
proprietor.
Kumarpara, Guwahati 781009, as the respondent number 8 to the instant proceedings. The petitioner is directed to file a amended memo of parties before the registry of this court by 5th of January 2024. And the registry shall, on the basis of the same, make necessary changes in the cause title of the petition and also upload the same in the CIS. The petitioner further is directed to take justice service upon the newly impleaded respondent number 8, routed through the registry of this court, and file an affidavit of service on or before the next date fixed herein below. List the matter again on 12th of February. In the meantime, the respondents out here, all the respondents are directed to file their pleadings, if so advised. I would not say about the 5 lakhs now, because if we find something, yes, there's some problem out there, we will award more. 5 lakhs is too less amount.
Yes, sir. Deeply obliged.
Interim order dated 22.
I've seen it.
That will continue.
Not necessary.
Deeply obliged.
It is already there. Yeah, I'll fix it on 12th. Because this court, if we find something, we will award more.
Nine.
Okay. None appears on behalf of the petitioner on call. It is also seen that on the last occasion, on an earlier occasion also, the petitioner was not represented. Taking into account the above, the instant petition therefore stands dismissed for non-prosecution. Interim order, if any. Yes, Mr. Bhattakur, this way. Oh, I can't take up this matter. Won't take up this matter. I have done their case.
Very well.
This is the matter before any other procure. This is that the one that they had this the hotel.
Lordship, a contract, his contract was partly allocated to another contract.
No, is this the person who had the hotel
Look,
out there?
look.
Na?
Look.
Rituraj.
11.
None appears on behalf, none appears on behalf of the petitioner on call. You are appearing?
Lordship,
Mr. Upadhyay appears on behalf of the irrigation department.
Lordship, in fact, Lordship, on that occasion I submitted, Lordship, there is no record, Lordship, of any allocation of work to the petitioner, Lordship. So that I have the instruction.
It reveals that on earlier occasions also the petitioner has not appeared. Further to that, during the course of hearing, Mr. N. Upadhyay, the learned standing counsel, had also submitted that there is no office records on which the petitioner bases its claim To that effect, an instruction have been placed before this court dated 15/9/2016, which is kept on record and marked with the letter F. Taking into account the above, this court therefore dismisses the instant petition.
Obliged.
Lordship, here I appear for respondent Apex Bank. We seek some time to Lordship reconstruct the brief.
Yes,
Matter became infructuous.
Huh?
Matter became infructuous.
then Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner, submits that the writ petition has become infructuous and as such he has instructions not to press the state. Accordingly, the instant writ petition stands closed as it had become infructuous. You give your name. Mr.
Yes, sir. Yes, sir.
Mr. S. Sharma, the learned counsel appearing on behalf of the petitioner, submits that the instant writ petition has become infructuous. Why?
You were apprehending that government may impose royalty upon extraction of earth upon us.
Ah,
Me. No sort of
has become
happened.
infructuous and as such has instructions not to press the instant writ petition. So taking into account the above, the instant writ petition stands closed as it has become infructuous. Who is there for the other side? Forest. Where is Mr. Bhattakur? I saw him just now. Yeah. You appear for all these people, na? The forest?
But perhaps our name was not reflected in the list.
Not
that's why-
necessary. Put your name there. Divisional Forest Officer, Mines and Minerals Department, all these things are there. Put your name. That's one of the three. Mr.
My lord, one of the respondents is my lord, PTC of Karnataka. Since I'm appearing as a PTC,
What is this matter about?
it is about my lord corruption in
Huh?
corruption in block development office in Damanpur, Baksa district.
Make an impartial inquiry regarding the misappropriation of money meant for the job holders under 20. You file an FIR? What happened?
My lord, case was registered, my lord,
Then
and from the affidavit it reveals, my lord, against those who FIR was registered, my lord, they were also arrested subsequently.
then what happened?
Then, my lord, there is no update.
No update? So,
My lord,
madam, you
my
give us the update.
my lord,
on
we
12th.
have, my lord,
On
Yes,
12th, you give us an update on that
My lord.
FIR.
my lord, we have filed the affidavit. my
I've
lord,
seen
in
it.
17
I've read your FIR.
My lord.
Ms. Yudas, the learned counsel, learned additional senior government advocate shall apprise this court on 12th of, apprise this court on the next date as regards the status of Kamalpur PS case number 244/2016 registered under section 420, 468 and 34 of the Indian Penal Code. Whose list the matter again on 12th of January
Right.
2024.
These two matters become infructuous.
You are respondent
I'm respondent
and you are saying that it has become infructuous.
infructuous and
In the second
Why?
item 16, I am the petition.
Let us first go to 15. 15 is 2816.
2816.
What is this matter about?
This is regarding constitution of the Guwahati Governance Committee.
Then
There was
it has already been constituted. Yes, it
constituted and there
has
was-
become infructuous.
maybe pass over for the time.
Why?
My senior,
Who is your senior?
Mr. K. Kolita.
Where is he?
He will appear in the court.
Huh? Wait. Customer should not be directing the conflict with the debt. Why these type of petitions are being filed out here? This is for the trial court to decide. Yes, the civil courts. We've seen the prayer of the petition.
He will appear in the court.
So you didn't get the file also. Open the file. This Guwahati Kobarstan is a Societies Registration Act. Finally comes in. Mandamus should not be directing the respondents to restrain the Guwahati area from being managed by anyone else except the petitioner. Now, who are the petitioners? Guwahati Kobarstan Committee. So the petitioner should not manage the petitioner.
Actually, I'm not very much aware of this.
And what is your case?
No, that pursuant to this inquiry report,
Ah.
the deputy commissioner had passed an order
Ah.
for handing over charge. That was challenged. But in the meantime, they had already taken over the charge. Their term is also complete.
Who?
This petitioner.
You've taken the charge.
They had taken the
Order, madam, 2017 order, madam. Whereby, madam, the order has been passed. To hand over the charge of Guwahati Kobarstan Jamal Ahmed.
Jamal Ahmed is the other one.
No.
Son of Jamal.
Both are committees now. Who is the petitioner? The number 2 petitioner.
Rahman, son of Jamal Ali.
Here the petitioners happen to be Guwahati Kobarstan Committee by Jamaluddin Ahmed. General Secretary is Jamaluddin Ahmed. President is Hakimul Islam. And the other one is Inamul Rahman. Jamal Ali is who?
Jamal 2816. The item 15. Petitioner is Jamal Ahmed 1. Guwahati Kobarstan Committee.
So they have been given the charge.
They have been given the charge. Already their term is complete.
So
So
you
nothing
have
is-
already got your relief.
Yes.
Madam, sir,
Are you not the petitioner here? Kindly see petition number 1. What they are represented by Jamal Ahmed.
On the honor, I had raised the issue of maintainability, whether it is maintainable or not.
Show me that, madam. Show me that order.
their prayer has
These
been
are-
accepted, madam.
This I have annexed your
It's okay.
at page 58.
In pursuance to the Honorable High Court's order dated and perusal of the inquiry. So you have already been given the relief. Then what remains?
Whatever you actually I have. I don't
Econo 2816/2017. Heard, mister? Your name?
W. Rao.
Yuanto, the learned counsel appearing on behalf of the petition. From a perusal of the petition, it reveals that the relief which have been sought for it in the writ petition is to give effect to the inquiry report dated 4/11/2016 and to ensure handing over the charge of the Guwahati Kobarstan Committee to the petitioners, enabling them to perform their functions and manage the affairs as the executive committee of the Guwahati Kobarstan Committee, Adgaon. The instant writ petition was filed on 4/5/2017. Full stop. Thereupon, on 7/6/2017, this court issued notice and further directed that in the interim, the pendency of the writ petition would not constitute a bar for the respondent authorities to take appropriate action in the matter in accordance with law. Mrs. Yu Das, the learned counsel appearing on behalf of the learned additional senior government advocate appearing on behalf of the state respondents, had submitted that pursuant to the order dated 7/6/2017, the District Magistrate, Kamrup Metropolitan District, had passed an order on 26/2017, whereby the inquiry report so submitted by Sri Gunojit Kashyap, ACS, Additional Deputy Commissioner, Kamrup Metro, dated 4/11/2016, was given effect to, and the petitioner herein, that is Jamal Ahmed as the president and Inamul Rahman as the general secretary, were declared to be legitimate and were allowed to hold the charge of the Guwahati Kobarstan Committee with immediate effect. In that regard, the learned counsel has placed before the court an instruction so issued by the District Magistrate, Kamrup Metropolitan District, which is kept on record and marked with the letter X. Taking into account the order dated 26/2017, passed by the District Magistrate, Kamrup Metropolitan District, the writ petition, therefore, requires no further adjudication, and accordingly, the writ petition therefore stands closed. Yes?
Okay. Secondly, the order passed by the deputy commissioner was challenged by us, but it has also become infructuous because that term is already complete. Second repeat.
Mr.
Azizad Ahmed.
Zidat Ahmed, the learned counsel appearing on behalf of the petitioner, submits that the instant writ petition was filed challenging the order dated 26/2017, passed by the District Magistrate, Kamrup Metropolitan District, whereby the inquiry report dated in pursuance to the inquiry report dated 4/11/2016, the respondent numbers 3 and 4 were recognized as the president and secretary of the Guwahati Kobarstan Committee. Full stop. The learned counsel submitted that in the meantime, the period have already elapsed. The period of the term have already elapsed, and as such, nothing remains to be decided in the writ petition. Taking into account the above, as the writ petition has become infructuous, the instant writ petition also it stands closed. Full stop. Interim orders, if any, stand vacated.
Much of it.
Yes. What is your instruction, Mr. Sharma?
Lordship, their claim is against the National Highway Authority, Lord.
And they have not made the National Highway Authority a party.
No, Lordship, they have made a party, Lordship.
Then
The National Highway Authority, Lordship, will.
They have to implement Lordship PIU Guwahati as party. Lordship, they have not made PIU Guwahati.
what is this National Highway Authority of India, New Delhi? Okay, none appears on behalf of the petitioner on call. It's also seen from the records that on earlier occasions also the petitioner was not present. Taking into account the above, it seems that the petitioner is no longer interested in the instant proceedings. Be that as it may, it is also seen from the records that the instant writ petition has been filed, being aggrieved by the inaction on the part of the respondent authorities in not making the payments, making payment of compensation. The remedy for such non-payment of compensation lies under the provisions of the National Highways Act. This is done under the National Highways Act.
No, Your Lordship, this is
Compensation.
compensation for accident, Your Lordship, not for land.
This is for accident, Lordship. The
Accident.
diversion mark was not there because of that, Lordship. The petitioner made it an accident with
I don't know,
with
like,
his
I don't know,
vehicle.
like, be that as it may, to continue. Taking into account the above, the petitioner is not interested, the instant writ petition stands dismissed for non-prosecution. Huh? Infructuous. Why?
Quality payment made. Payment of ex gratia, my lord, claiming of ex gratia.
The learned Mr.
Etera.
The learned counsel appearing on behalf of the petitioner submits that the pursuant to the filing of the writ petition, the petitioner have already received the ex gratia, and as such have instructions to withdraw the instant writ petition. Taking into account the above, the instant writ petition stands closed as it has become infructuous. Yes, madam.
Okay, Lordship, in this case, Lordship, the main question, moot question for your Lordship is whether my transactions, I have given my launch vehicle on hire, whether that would amount to transfer of right to use goods or service tax. Because Lordship, I
What
paid
did
both.
you do?
Lordship,
You
I give launch vehicles to railway,
launch.
launch vehicle.
What is that?
Lordship, this my contract agreement, Lordship, is at Annexure 1, page 42. There is a Lordship that Bogibeel Bridge was constructed across the river Brahmaputra near Dibrugarh.
A launch vessel in connection with construction of Bogibeel Bridge. So you say that it is no lease. It's not a lease.
Lordship, it can, Lordship, my moot question is that whether it's a transfer of right to use goods or whether service tax, I have paid both.
Huh?
I have paid both. Because Lordship, what has happened? Lordship, I'm an unregistered contractor in the state of Assam. I transferred this launch vehicle to the railway. Now, Lordship, we filed a clarification petition before the department. They said that no, I have got two contracts. They said that no, it is not liable to VAT because it is not a transfer of right to use goods. So we, Lordship, paid the service tax on those transactions. That it is a purely service contract. Now, Lordship, thereafter, when I paid for, because VAT was but deducted by the railway department from us, that was deposited in the government account. So with this TDS challenge, we went for a refund of the VAT. That since it is not the transfer,
They are not refunding it.
they did not refund. Instead of refunding, Lordship, the superintendent of taxes, what he did is that he wrote to the commissioner for review of this order. So, Lordship, the commissioner, Lordship, who had earlier given me clarification that it is not a transfer of right to use goods, he, Lordship, reviewed the order, and now he is saying that no, it is transfer of right to use goods, and VAT is going to be payable on this. So, you are not going to get the refund. Now, I have paid both service and service tax as well as VAT.
So
Lordship,
now thereafter you have approached the service tax authority.
no, Lordship, I have not approached anybody.
Service tax there, he
I am-
comes.
I am ready to pay service tax, not the bad lordship, because it, as per my lordship, understanding of the contract agreement goes, the service, it is, we are liable, we may be liable to pay service tax, not bad, because my contract is purely service, not lordship, transfer of right to use. So that is my only lordship, question, lordship. I will take lordship to the facts of the case. They have filed an affidavit, also in this case. Lordship, what had happened, lordship?
You are there for service? No. See, here is a question as to who is liable to pay, whether a person can't be imposed of both. Either it will be service or it will be VAT. So if it is a transfer of property, then in that case, it would be VAT. But if it is purely a service thing, then it would be you. You are made a party?
Yes, yes. 5, respondent number 5.
Alright, you are there. Because you have received both. So here the moot question is whether it amounts to a transfer of property
Yes,
in
sir.
goods,
It's the deemed sale or not.
deemed sale or not,
That's it.
But 42nd.
and whether it has been used, whether the control is given to you.
That's the whole.
Rashtriya
But
Ispat
we'll have to
Nigam.
go through the various clauses of the
Whether the control is given to, whether I have passed on the control, whether while giving the launch vehicles to the railway department, whether the control remains with me or whether I have transferred my control to the railway department. If I have transferred my control or to the railway
That
department.
judgment, na, Rashtriya Ispat Nigam or something like that, I forgot.
Ispat Nigam is there, Lordship, and many other judgments are there, Lordship. In fact, Lordship, I was thinking of making compilation of the judgment.
Don't. Compilations are not for this court. Compilation is when I dismiss or allow your repetition, either of you to place it before the division. For me, let us make it very simple.
Lordship, I will place only one judgment, Lordship, that will clarify the entire, Lordship, what exactly is the law which is prevailing as on date. Lordship, this is a judgment of the Tripura High Court, division bench judgment.
Which one?
Lordship, this
It
is
is Swapan Kumar Paul.
yes, yes.
What does it say?
Lordship knows that. Lordship, that Lordship, I'll just read to the head note and thereafter the whole judgment. Levy of VAT, section so and so of the Tripura, whether transactions entered into by the petitioners amount to transfer of right to use any good and therefore they are exigible to tax in terms of section 4.2 of the Act, read with rule 7 of rules, held there is both an element of service and transfer of right to use goods. It is, however, appeared that predominant portion of contract relates to hiring of services and not to transfer of right to use goods. It is a settled law that when contract cannot be divided with exactitude, then central law must prevail. Parties have also been paying service tax, and if state is allowed to tax any portion of value of contract, then there has to be proportional refund of service tax to that extent. This cannot be done without hearing the central government. If there is any dispute between state or central government, they must resolve it between themselves. Petitioners or NGC cannot be made liable to pay 4 taxes for the same transaction. It is for the state in consultation with state government to come up with.
No, where is that Rashtriya Ispat Nigam? That judgment, not this. Rashtriya Ispat Nigam, that judgment.
But if
Ah,
yes, then other judgments have all been discussed.
Here we have to only see as to whether it has the control.
Yes,
You
sir.
have the control or not.
Whether the control remains with me or whether I have transferred my control to the railway lot. All the earlier judgments got then I pay back the
This one,
Paragraph 32.
2002, 3 SCC 314. As the owner of Visakhapatnam Steel, it engaged various work contractors to do the work and supplied sophisticated materials. Higher charges for the same. The tax was levied on this transaction on the ground that there was a transfer of the right to use the plan. The judgment held that there was no transfer of the right to use the vehicle. And then the High Court analyzed the various causes and held that the contract was not free to make use of the vehicle for work other than tax work or move went on. So the test is what? What is the test?
Lordship, whether the control remains with your lordship, whether I have transferred my
That we
control
can only come to now
after going to
know
the-
whether it is the one has to look into these terms of the contract.
Clauses of the contract.
And your lordship, so far as service tax and VAT are concerned, lordship, it is very well settled that I can say judgment that they are both mutually exclusive. Lordship, it is not expect theory will not come.
Hmm?
Lordship, expect theory will not come to picture. It cannot be like that, like custom tax. If you are bringing any goods into the country, or if you are bringing any goods to the state, and lordship, central excise is also the central sales tax is also levied, entry tax is also levied. Lordship, but for the same transaction, both the things are levied. That is allowed so far as aspect theory is concerned. But when it is the case question of service tax and VAT, it has been held that they are both mutually exclusive. So it can be only one thing can be levied. That has also been lordship, that is the settled problem. I can please judgment. Even in this judgment, lordship, at paragraph 32, the court has held that both service tax and VAT are mutually exclusive. So either one.
The judgment out there of the division bench of Tripura,
Yes, yes.
wherein it says that the central government, the central tax will prevail over the state.
And lordship, if it can be divided into such that some part of the central, we can show that this is a service part and this is a material part. Then it's lordship, then we can buy a service.
So if
tax
it
and
is
service
divisible, then it can be.
then it can be. If it is like hiring of service where I cannot divide it because I am getting one payment of that, whether it is a sale or whether it is a service, it is not discernible. In that manner, lordship, this held that the central act will prevail over the service tax. If it is, if the lordship, if in this type of indivisible, this is what has been held by the.
No, that was held in that context.
That-
That when a sale or service is done in such a manner, it is very difficult to ascertain
Yes.
whether it is a sale or service,
So service.
or is it so composite enough that it cannot be done. Then the question is, this court finds it difficult to hold it because if we apply that law, then tomorrow, whenever there is a confusion, then the central will get and the state will be deprived. That can't be the law. The fact is to be looked into. That is why I said about there are two judgments. One is Rashtriya Ispat Nigam and the other is BSNL.
Yes,
These are the two judgments. Now, BSNL was a case pertaining to mobile phones, mobile, if I am not. So there the issue out there was whether it would amount to sale or service. And Rashtriya Ispat Nigam is similar to out here, where there was a leasing of certain instruments, Visakhapatnam thing, I suppose. Huh? Yes, yes. So I think with those two judgments, I think, or any other development of law thereafter, I don't know much on that. But these are the two main judgments on which. But this court finds it very difficult to say that when there is a confusion that the central law will prevail, that would have a far-reaching consequences.
but dominant nature may be seen that it
Because you see, there has to be a service. There has to be it has to be within the fold of a service tax. Then only one can get it. But the moment it is a confusion, it will say, let us wash our hands, let it go to the central government. That will have a disastrous consequence. What do you say, Mr. Kyle? He also accepts. Chalo, we'll hear it when.
It is convenient for that.
Hearing the
We'll hear it on 18th. Get a small compilation. 18,
18.
1-8. This is the matter again on 18th of January 2024 for further consideration. That is the only issue.
Paragraph 4 and second paragraph of page 32.
The instant petition was filed by the petitioner, challenging the communication dated 16/12/2020, wherein the respondent number 4 was allotted the milk stall at North Lakhimpur, NLP,
Not look.
what is North Lakhimpur station, and for a direction to the respondent authorities to allot the VIP Amul store at North Lakhimpur station in favor of the petitioner. It is apparent from a perusal of the affidavit in opposition filed by the respondent
1, 2, 3.
1, 2, and 3 that in terms with the catering policy of the respondent railway of the year 2017, an open tender was invited by NIT number C/56/RNY/CATG dot oblique milk stock M to the /19/1/NLP full cap dated 16/12/2019 to the www.ireps.gov.in web portal, and the said tender was opened on 31/12/2019. The petitioner did not participate in the said tender process. The respondent authorities, after taking note of the tender of the respondent number 4 and finding it to be suitable, has awarded the contract in favor of had awarded the license.
Letter of acceptance, license.
Letter of acceptance of the license in favor of the respondent number 4. By the communication dated 16/2/2020.
16/3.
16/3.
The original one, what you will find in my affidavit in opposition. Page
No, they
126.
have enclosed something.
It's a typographical error, my lord, in the type copy.
16/3.
Page 126.
16/3. Full stop. taking into account that the respondent number 4 was awarded the letter of acceptance of the license dated 16/3/2020 in pursuance to a tender process wherein the petitioner did not participate, comma, the question of interfering with the letter of acceptance oblique license dated 16/3/2020 in favor of the respondent number 4 does not arise. Further to that, it is also relevant to observe that as per the catering policy of 2017, allotment of licensed premises can only be given by way of tender. And as such, the question of issuance of a direction upon the respondent authority to grant allotment to the petitioner on the basis of a representation also does not arise. Consequently, this court therefore does not find any merit in the writ petition, for which the writ petition stands dismissed.
But another that has to be corrected, my lord. NIT is dated 6/12, not 6. NIT dated 6/12/2019, page 120, not 16.
Here you have mentioned it wrongly in your affidavit.
I apologize.
Well,
But
you made mistake. Where is the NIT?
page 120,
120
and 120.
number to subject C /56 RFY category is bill call 2019 1 dated 6/12/2019. Page 120.
I apologize. It was drafted in a hurry. Much.
Item number 20.
Is it clear, please, my lord? I put the respondents here.
Yes, what is the case?
Yes. I beg apology, I could not file the affidavit in opposition.
You have filed it?
No, I take some time here, 2 weeks.
Release of my lord, enhanced amount, my lord, for 3 years, my lord. Decision itself, my lord. Mediation center. In mediation center, just where there 2/11/18 or things like that. Order dated 2/11. Amount
Yes,
is,
Mr. Das, what is your case?
my case is, my lord, 2 lakh, my lord, according to me, 60,984, my lord. That is the amount payable to me, my lord.
Why?
Because, my lord, there was an agreement for 5 years, my lord, for install to provide the, my lord, electricity by by installation of the DG set, my lord. This set, my lord, diesel generator by the LIC, my lord. Here, my lord, after 5 years, it was enhanced for 3 years, my lord. But they have not
It was extended for
extended for 3 years, but they have not given given me the, my lord, enhanced rate of the detail, etc. That is why, my lord,
where is the agreement?
agreement, my lord, that is I have next year, my lord. Page, my lord, 20. Original that is also there.
No. Where is it that about the extension?
Or
You are entitled
extension,
to.
my lord, they have not extended. Page 25 was the earlier, my lord.
Huh?
Page earlier agreement was, my lord, 13/3/2010, my lord. But that has not been enhanced. But they have issued one letter saying that, my lord.
Wait.
Last
First
page.
of all, your agreement was from which time to which time?
Yes, my lord. That is, my lord, period is, my lord, 15/6/2010 to, my lord, 15/7/2015.
15/6?
2010 to 15/7/2015.
15/7.
15. But they have.
This is more than 1 year. more than 5 years. Can't be.
Yes.
It will be 15/6/2010 to
Yes.
15/7/2015.
Yes.
Will be 5 years, 1 month.
Yes, yes.
Okay. Then
Then, my lord, it was extended for another period of 3 years, my lord.
from
My lord, that is, my lord, 16/7/2015. 16/7/2015 to, my lord, next period, my lord, 3 years, my lord, that is counted. They have my lord, that is 18/6/2018.
18/6/2018. Okay. Then
My lord, we have submitted representation before the my lord, LIC. They have, my lord, accepted and said that, my lord, it can be extended. The amount of the 3 years, that difference of the amount can be enhanced, my lord.
where?
That is the last page, 38.
This is only for the period from with effect from 1/6/2018.
Yes, my lord.
Then
On that day, they have told that, my lord, it can be extended after 18/6, my lord, but otherwise not from 15/6.
Huh?
Not from 15/6. My representation, kindly period your lordship, that is page 36, annexure 8.
yeah, but the agreement had already expired on 15/6. Why
Yes,
you are
sir.
saying 15/7? That is what I'm.
Yes.
So you wanted granting of around 40%.
40%, my lord. That is 2,60,984. They have accepted.
Where? Where they have
They accepted, my lord, 18/8/2018.
Huh?
Uh,
You have not enclosed that.
Okay,
That is the main
subsequently
document.
I have received. Subsequently, my lord, I have received.
Where?
After filing the case, my lord, I have
Then what was happening?
now they have not given to us. Even
No.
on mediation, they wanted to provide me, my lord, only 50,000+ rupees, my lord. So we refused the
No, what is this document with the no sign, nothing?
that they have received that paper. It was my calculation that it is.
Oh, they have not accepted anywhere.
They have signed here.
They have signed it. What?
Only
They have received your proposal.
Receive, only receive.
Then wait. How a REIT will be maintainable?
And that is subsequent, but
These are different things. But
Uh,
how a REIT will be maintainable in this case? Tell me. You have asked for a particular amount on the grant on the basis of an enhancement.
Yeah.
How can this court decide on these aspects?
But in mediation also it is.
Mediation is very good. Mediation is all outside the court. If
Then
you
we
have
have
agreed
achieved
to
my,
50,000 more, you would have been happy out here. But here you are going to get a dismissal right away.
But giving liberty to fight approach with court.
That is
Observation,
all,
because, my lord, case is pending before this honorable court matter.
So you want to file affidavit?
Lordship,
Then take your seat. Let me pass the order. The instant writ petition has been filed by the petitioner, being aggrieved by the inaction on the part of the life insurance on the part of the respondent in not granting enhancement of the rent in respect to the 25 kVA DG set which was supplied by the petitioner. It appears from the records that the respondent authorities had taken on hire a 25 kVA DG set for a period of 5 years with effect from 15/6/2010 to with effect from 16/6/2010 to 15/6/2015. It further appears that thereupon the respondent authorities continued to use the services of the petitioner in respect to the DG set even after the expiry of the same period. And under such circumstances, on 18/6/2018, the petitioner submitted a representation to the manager, to the respondent number 2, for enhancement of the higher charges by 40% above the rate which was at a rate which was fixed in terms with the agreement entered into on 15/6/2010. However, the respondent authorities did not grant the enhancement, and on the other hand, informed the petitioner that the competent authority would consider the revision of rent with effect from 1/6/2018 and also informed the petitioner that a tender would be issued for a new DG set, and the petitioner was asked to participate in the said tender process. Being aggrieved, the petitioner therefore has approached this court seeking a direction upon the respondent authorities to pay the revised rent with effect from 16/6/2015 till May 2018. It appears that after filing of the instant petition on 18/7/2018, there were this court had placed the matter before the mediation cell of the Guwahati High Court. It is also apparent that on 1/11/2018, the mediator so appointed had submitted a report stating inter alia that in spite of repeated endeavor, the matter couldn't be settled amongst the parties, and hence the matter was referred back to this court. The record further reveals that on 2/11/2018, this court had issued notice. However, in spite of the passage of more than 5 years, 6 years, 5 years, the respondent LICI, the respondents have not filed the affidavit. During the hearing of this court proceedings, this court had put a specific question upon Mr. H. Das, the learned counsel appearing on behalf of the petitioner, as to how this court would be in a position to decide the extent of revision of the price, as the same would entail entering into disputed questions of facts as regards the price of the fuel, as well as other ancillary items. The learned counsel appearing on behalf of the petitioner most with his usual fairness has submitted that these aspects of the matter cannot be decided in a forum decided in a forum cannot be decided in exercise of the powers under Article 2 to 6 of the Constitution, taking into account that there would require adjudication of various aspects as regards the rise of the price, the rise of the hike in the diesel prices, as well as the other ancillary items. Taking into account the above, this court therefore is of the opinion that the instant writ petition would not be maintainable, as these aspects as a question which has been raised as regards the enhancement to the extent of 40% would require decision on merits, a decision on various factual aspects, including going into detailed evidence as regards the loss suffered by the petitioner on account of providing the services during the period from 16/7/2015 to till the month of May 2018. However, this court cannot be unmindful of the fact that the petitioner had been diligently and bona fidely pursuing the instant litigation. Accordingly, in view of the above, the instant writ petition stands dismissed on the ground of non-maintainable, on the ground of non-maintainability, on the ground of disputed questions of facts. However, the dismissal of the instant writ petition shall not prejudice the petitioner in availing remedies otherwise available under law. This court further, taking into account that the petitioner has been bona fidely and diligently pursuing the instant litigation, and there being no affidavit filed by the respondent authorities which has led to the delay in the proceedings, is of the opinion that the petitioner would be entitled to the benefit of Section 14 of the Limitation Act 1963 during the period from the date of filing of the instant writ petition, that is on 18/7/2018 till today.
Hello. Here, in this case, my lord, the interim order is here, my lord.
Leaves the matter after 2 weeks. Till then, operation. 2 weeks is long over in 2018.
Yes, my lord.
We are in
My lord,
2024.
This post, my lord, of my lord, Gavura is it is not, it is vacant, my lord. Because that dispute was, my lord, regarding, my lord, age, my lord. 35 years was there, my lord.
Now nothing remains. All these amendments have happened. What happened? What remains?
Okay.
Nothing. Mr. H. Das, the learned counsel, appearing on behalf of the petitioner submits that in view of the subsequent amendments made as regards the made by notification dated 2000 22nd September 2021 by notification number. You give us this copy so that we can put it properly. Submits that in view of the notification bearing number RLR.73/20/20 oblique 73/2020/3 dated 26/8/2021, whereby the amendments, whereby various other amendments were carried out to the whereby the amendments were carried out to the executive instructions under the Assam Land Revenue Regulations 1886. The instant writ petition has become infructuous. So taking into account the above, the instant writ petition stands closed. Don't worry. Yes. What is the case about?
The pollution control board to the cost of amount, my lord. It is that, today we have had to follow the.
Who?
The RD and FA.
R?
RD and FA. I said.
You have filed wakalatnama
yes,
today. Why?
My lord, the earlier question, my lord, Garnet Council, Mr. PN, they are in case. But he keep the NOC yesterday.
So the matter came up immediately today. Yes. What is it?
It is with regard to imposition of environment compensation fine for not installing effluent treatment plant. So they have been imposed with the fine and agreed by which they have approached this court. And finally, in the year 2022, the board set over the matter, and the industries units which have already established the effluent treatment plant, that cost has the imposition of that fine has been waived off.
This way you have waived it.
Yes, that this is the order which speaks of some 416 numbers of industries and 70 number of industries where fine has been imposed, has been waived off.
Including this
by
one?
Way of, very almost all, because that cannot be an exception. So I'm not sure whether the petitioners in
We will get you.
So nothing survises.
You were given a closure notice?
I don't ever about this back. The environment compensation fine.
No, it has been waived in respect to 73 numbers of industries.
Yes.
And the list is uploaded there. Find out that. See the copy.
I have seen
in
the website.
So do you want this court should type out the website and find it out?
I thought
Find it out.
I thought the petitioner would have been in
Why the petitioner would be?
Because
You
already-
know the state of affairs of the petitioner. Only last evening he got the
Yeah.
NOC. Yeah. See the state of affairs. Okay. The instant writ petition has been filed challenging the imposition of environmental compensation fine as per the NGT order dated 19/2/2019 by an order dated 24/10/2019. During the course of hearing, Mr. S. Porua, the learned counsel appearing on behalf of the Pollution Control Board, had submitted that in terms with the resolution adopted in the 103rd board's meeting, the closure notice issued by the board to 416 numbers of industries in the year 2019 have been withdrawn. Further to that, the environment compensation fine levied on 73 numbers of industries have also been waived. Also, it is, however, not clear from a perusal of the said communication which have been placed before this court, dated 10/3/2022, as to whether the petitioner's hotel features amongst the 73 numbers of industries as mentioned in the public notice dated 10/3/2022. Mr. S. Borua shall obtain the necessary instructions in that regard and place it before this court on the next day. List the matter again on 24th of January 2024. I'm giving you a date. Now you prepare it properly. The communication, the public notice for placed before this court is kept on record and marked with the letter X.
It's not before your lordship, my lord, is challenging the impugned order dated 19/5/2020, my lord. It's annexed Q, by which, my lord, the private respondent was awarded the contract of the fishery, my lord. Although,
Contract
my
of?
lord, fishery, my lord. Although he
When?
is not qualified, my lord.
And you gotta stay.
No, my lord.
Then?
So he is running, my lord.
What is the corporation department doing here?
Lordship, the
Fishery and corporation department, what is this connection?
because, my lord, on the last occasion, my lord, when the matter was listed before his total matter, he made it clear whether, my lord, one certificate can be issued by the agriculture department or by the, my lord, it's a cooperative.
What certificate?
This, my lord, fisherman certificate, 100% fisherman certificate.
That cannot be given by the corporation department. That has to
Yes,
be
sir.
given by somebody else.
Lordship, this society, assistant register of cooperative society or register of cooperative society empowered to issue the certificate, those which are the societies registered under section 11 of the Cooperative Societies Act. And so far the other NGO and self-help group which has been authorized by the Rule 12 of the Assam Fishery Rules 1953, that authorized to participate in the tender proceeding. But in the NIT, there was a clause that was given that the certificate, 100% fisherman certificate, that should obtain from the cooperative society, assistant register of cooperative society, which is not possible for the NGO as well as for the self-help group. That was only the dispute, and the tender calling authority, who is the supreme authority who can decide and analyze whether any technical defects or analysis of the document is correct or not. That has been done by the government, and accordingly, government has decided that
Have relaxed it.
no, not relaxed.
Then?
Since the proper authority is the DFDO, therefore the 100% fisherman certificate has been issued by the district fishery development officer. That is acceptable. That is the case. In the comparative statement, my lord, his bid was rejected. Not rejected. I am the valid. I am the second highest bidder and also valid highest bidder.
Where is the cooperative society? Where is the comparative statement?
Statement, my lord, lordship will find annexure M page 36.
Page 30?
36, my lord.
Okay.
Relevant is page 37, my lord.
What is the name of him?
You-
You are appearing for whom?
I am for the private respondent.
What is his name?
Kevji Banana.
Huh?
Kevji Banana.
If your lordship takes the affidavit filed by the fishery department, we have annexed the relevant record. That will clarify everything for us. Affidavit filed by the respondent number 1, Lord. Your lordship.
Yes.
I'm placing it from the annexures, lordship. Lordships may kindly come to annexure page 9. Annexure 2, page 9.
Hmm.
This
Yes.
is Tulsi Das, Secretary, KUG Banana Growers Committee. This is the respondent number 5, private respondent.
Hmm.
And down below, Samiti Das is the petitioner. In respondent number 5, first line, Lordship, 100% actual fisherman certificate by ARCS.
Hmm.
N means no.
No.
No, not submitted from the Department of ARCH. And the petitioners, it was submitted. The others relevant documents are everything, all are yes. Then Lordships comes to next page, page 11. This is the minutes of the tender advisory committee meeting that is so and so. In serial number 2, in the document filed by Sri Tusil Das, Secretary, KUG Banana Growers Committee, it is found that 100% actual fisherman certificate by ARCH has not been submitted. Next 3, it is found that the document submitted by Srimati Somiti Das, Secretary, Guhaigaon, Bahumukhi Mohila Samabay Samiti are in order. Then down below, in view of the above observations, the tender advisory committee has decided to recommend the tender of the Somiti Das, Secretary so and so, that is the petitioner, for settlement and to forward all the tender papers and documents to the government for further necessary action. Then Lordships comes to page 13. This is the order of the fishery department. Serial number 2. Has your Lordship, the SHG offered rupees so and so, that at the rate of rupees so and so, which is the third highest.
Which is SSG?
Self-help
Yours.
group. No, this is the
I'm
petition.
here.
The private respondent.
Yours.
Yes.
You are the third highest.
Yes.
Okay.
And others were rejected, Lordship. Only petitioner and this private respondent, their tenders were accepted. Then 4.
No.
This is the petitioner.
SSG is here. The SSC has not 100% Iman in terms of Iman, but the Pathar Iman PPS is registered at the district when disconnected beta has furnished a certificate issued by TFTO. Both as 100% as well as experience which is accepted. All other documents.
Which is accepted.
Society is located within the neighborhood of the areas of the
Then Lordship may skip the 3. Next 4, that is the petitioner. The society is offered rupees so and so, and other documents are found to be in order. Then Lordships may turn to next page, page 14.
Now, we are concerned with which fishery?
Number 22, Laipulia Min Mohal.
Laipulia Min Mahal. There were 5 tenderers.
Okay.
3 were rejected. The petitioner as well as the private respondents, their tenders were accepted. Now read the reason at page 14, just down below the Roman 4. Thus, out of 5 bids, has your Lordship got it? 2 bids are valid. One offered by Seuji Banana Growers, that is the private respondent, at rupees 10,99,000 so and so for 7 years, which is the third highest bid. And the other offered by Messrs so and so, which is the petitioner, for 7 years, which is the 5th highest. From the scrutiny of documents, it can be seen that the private respondent is in the neighborhood of the fishery within 300 meters than the petitioners, which is located at a distance of 9 kilometers from the fishery, and thus the bid of the private respondents is more acceptable, which is higher bid, as well as the neighborhood of the fishery, which is in conformity with Rule 12 of the Assam Fishery Rules. So this is the reason, Lord.
Well, page 12, madam, the tender condition method. It says this, the certificate issued by the ARC is the compass. Page 12.
Of your petition?
My lord. May I read?
Yes.
100% সম্পূর্ণ মাছমৰীয়া হোৱাৰ প্ৰমাণপত্ৰ সহকাৰী পঞ্জীয়ক সমবায় সমিতিয়ে ARCS মাছমৰীয়া সমবায় সমিতি আত্মসহায়ক গোট বা NGO দিয়া 100% মাছমৰীয়া হোৱাৰ প্ৰমাণপত্ৰ আবেদনৰ লগত জমা দিব লাগিব। ফিছ মিলত মেণ্ডেটৰী উল্লেখযোগ্য নিবিদে জমা দিয়া মাছমৰীয়া সমবায় সমিতি আত্মসহায়ক গোট বা NGO সকলো সদস্য অনুসূচিত জাতি জনজাতি সম্প্ৰদায় বা পূৰ্বৰ অসমৰ কাছাৰ জিলা মৈমাল সম্প্ৰদায় হোৱাৰ উপৰিও উল্লেখিত ARCS ৰ প্ৰমাণপত্ৰত উল্লেখ
No, read page 12, number 3.
মাছ ধরা অভিজ্ঞতা প্ৰমাণপত্ৰ।
জিলা মীন বিষয়া DFDOৰ দ্বাৰা জাৰি কৰা মাছ ধৰা অভিজ্ঞতা প্ৰমাণপত্ৰ জমা দিব লাগিব। In addition to this, man. In addition to number 1, man. All are, my lord, mandatory, man. If one is keep, my lord, he is invalid. He is invalid. That is my humble sense of people. When tender condition specifically said, my lord, you have to submit one certificate issued by the ARCS, my lord. You cannot, my lord, skip that document. This page 12 is, my lord, categorically
Yeah.
says that.
It is also reflected in page 13 of our affidavit, Lordship. If we go by that serial number 2, the SHG, the self-help group, has not furnished 100% actual fisherman certificate issued by ARCS Dhemaji in terms of clause 1 of NIT. But the Pothar Porichalona Samiti is registered under the district agriculture officer Dhemaji. In this connections, BITAR has furnished the certificate issued by the DFDO Dhemaji, which covers both as 100% actual fisherman certificate as well as experience certificate, which is accepted.
It is, my lord, in compliance with, my lord, item number 3. Man. Where is the, my lord, item number 1? Yes, yes.
And regarding the
Sorry.
regarding the petitioner's lordship, if your lordship comes to the last line of page 13, however, this is regarding the petitioner, page 13. However, the experience certificate issued by the DFDO Dhemaji has not specifically mentioned the word experience. Although the activities described in the certificate, it can be construed as experience certificate. So he has got some lacuna, the private respondent has got some,
But he has submitted the DFDO certificate.
lordship, but there the experience, the as per the NIT.
But you have not rejected his.
No, lordship, neither the petitioner nor the
No,
private.
you have not rejected. But why you have not rejected him? When you
Lordship,
have a
because-
specific term out there in the contract.
Yes, yes. It is specifically mentioned here itself, lordship, at page 13.
Don't you think that there will be many other competitors who would have done it if you have relaxed that?
Regarding the others, lordship, if your lordship comes to that comparative statement, we have annexed at page 8. Starts from page 8. This is one of the tenderer. Baki, the 100% actual fisherman certificate by so and so not submitted. If we then lordship, the Bakijai certificate not annexed, scrutiny deposit not annexed,
No,
society.
if you
PAN card-
wanted that, couldn't it have been a case of a retender? Because that is a very essential
Lordship,
certificate you said, and he has not given the English translation of the entire NIT.
Not mine.
No, lordship, if when
But,
any
If you don't give any of these documents, you will be, because how does the sport otherwise see this yardstick?
Lordship,
Yes, you
that-
can very well waive it. Maybe on whatever reasons you may waive it. But you are not, are you waiving it? Then why was the necessity of putting the clause
Lord,
3?
Lord. Had there been any waiver, lordship, in that case, the other tenders should also be given that opportunity.
The other tenderers would have,
That is the law, Lord. Yes, Lord.
there would have been more participation.
Lord,
Yes, now you say,
My humble submission is that
you have enjoyed
Uh,
more.
since there is no any other provision or specific speaking order, has
Understood. For that, you should have challenged the tender.
even though lordship, after lordship, there is an speaking or there is an OM that has been passed by the department. But in the said OM also, lordship, nowhere option has been given to issue certificate by the ARCS. Lord. That is the main difficulty.
No, they may be thinking
And,
that we are
so far
only
the
going to give it to
other
those.
tender proceeding is also
No,
concerned,
they may
lordship.
very well think that we are only going to give it to the cooperative societies, registered cooperative societies. That is why they have asked for this. Now, you
No,
are
no,
taking away,
But lordship, authority cannot deprive a person who has been
absolutely, but
provided the
for
right
that,
by
for
by the-
that, you have to challenge the tender condition, which you have not. You have not challenged the tender condition.
I
So
have not
the
done.
tender may be wrong.
Yes.
That is a different aspect. But as of now, the tender remains as it is.
But so party lordship,
Because tomorrow the authority may very well say that we only require societies, the cooperative societies which are registered, not others. Like the 100% fisherman certificate, as I told you, is to be given by the DFDO. It can be the register of cooperative societies. They can't give that.
yes, yes.
But the fact that they want the certificate from the ARCS means they want a cooperative society. And they are giving it to an NGO. Why would not the petitioner be aggrieved?
Because lordship, so the rule has provided the right to the NGO and self-help group, but
Understood.
yes.
The rule may have provided all these
so
things, but
party-
the fact remains out there
So-
that you are not competent, you are not eligible at all.
So far the interpretation part is concerned, and the most one of the most
Tomorrow
important,
the tender committee wants a company, not a private person. They may say that we want a company. Then if they give it to a private person, then what happens?
lordship, but so far the petitioner part is concerned. If the 100% fisherman certificate, that is the prime requirement. The another prime requirement was lordship clause number 3. Though petitioner has not given the translated copy, there must be a specific word obhigata. This is called experience. But that certificate indicates that he has not possessed the experience. That is in lacunas on the part of petitioner. Petitioner having not qualified as a qualified bidder, lordship, he has selected before the honorable court.
My goodness.
Because lordship, this is the important clause. Because the authority has interpreted this certificate issued by the fishery development officer.
You see, there are two different things. As per FCONS, if we go by that, the authority concerned is the best
Yes,
who
sir.
knows about. Now, the authority concerned makes it very clear that we need a cooperative society. There the cooperative society. Now, the authority concerned has the flexibility to accept the certificate as a 100% certificate by them as an experience. That the authority concerned has the liberty. But can you say that the authority concerned who has the liberty or who is the author who categorically mentions that we need a cooperative society and says, give a goodbye to all this cooperative society business, we give it to him because I like his face more. Something like that.
So far the only my humble submission before this honorable court is that since yes, I have not challenged the NIT provision of the NIT as well as the office memorandum that has been passed by the authority, but the interpretation which has been made by the authority, that I think it is appreciable because authority has no power to issue certificate those who are not registered under the cooperative society.
Understood. So they have entirely excluded those persons who are not there, for which it may affect your right under 19(1)(g).
Yes.
For which you can very well challenge the term. But can the society, the tendering authority say that we need cooperative societies and say that forget about the cooperative society, I like his face and give it. Isn't it a glaring example of arbitrariness?
Because their bid amount was higher,
Huh?
that is why it was accepted. But even that lordship, that is
Bid or no bid, how does it matter? The bid will come
That is
later
not
on. The price bid will come later on. Then you give it to anybody. Then why do you have all of these terms and conditions about this fisherman certificate or this certificate, that certificate? Not necessary. Whoever bids the most, I will give it to him.
But in case of any waiver of that clause, lordship, the other tenderers should also be given the opportunity.
Absolutely.
That is
Because
the
there
law.
will be many other people.
Yes, lord.
Yes, sir.
Then,
If that is not
so
done,
are you
lordship,
not
in
being
that case-
given a better facilities for that?
Only,
Chalo, I allow
my-
his petition.
lordship, only my humble submission before
So
the honorable
lordship will
court.
allow or
Lordship, in case of
go for a fresh tender.
Hmm?
Go for a fresh tender or allowing the retreat.
No, I will set aside his. Then I leave it to you. I'm not going to give it because this court is not the authority out there. You take a decision, whatever you want to do thereafter. You want to give it to him, like his face, give it to him. That is his
Only that observation may be made, Lordship, because I would like to rely on the judgment that was passed on because your Lordship has not directed to retender. Therefore, only because only I would like
You
to rely
want
the
this
judgment
court
because-
to dictate in as to how the authority
No,
wants to
Lordship, only-
tender.
only I would like to rely the judgment because,
Which one?
because they are the authority who can interpret the document, Lordship, that only that part.
Interpret the document very well, but when they have a specific
Galaxy
term,
Transport Agency, only that.
which
judgment I-
judgment? Tell me.
Lordship,
Which one? Name of the party.
Galaxy Transport Agency.
Oh, Galaxy. That is
Yes, sir.
okay. That's by Justice Rohington Nariman.
Yes, sir.
Paragraph 18.
Paragraph 15, 14, 15, and 16, Lord.
That is one following Afcons.
Yes, sir.
He has just quoted paragraph
And-
15.
This judgment they have.
Dispose.
I leave.
I'm setting it aside. Do whatever you like thereafter.
Lord.
And in the meantime, you run it through whatever means.
Yes, Lord.
Keep up.
Party department.
I leave.
I'm sorry to say that regarding Article 23, there is an interim order. Yes,
Which one?
Article 23.
Pollution.
23.
Pollution one.
Yes, yes.
I fixed it on the 23 to in terms of the park. And let it.
Okay.
For the order dated 15/12/2023, the government is supposed to produce the
What are you asking?
time for non-releasing of the rent.
Release the house rent and
25
amount we have
per
per
month.
month to the no.
So,
House rent from whom?
from the DC road.
Huh?
DC road,
Why?
because they have starting a bit of school debut cycle office to my
Have they left it? Have they left it?
Yes.
They vacated it.
Yes, they have better food. on
Now
food.
you want the money for this period. And why did you file it in the year 2020?
Because on 2019 is the last representation.
Forget about representation. Representation does not extend the period of limitation.
But limitation I have just referring.
Yes, madam. You are appearing for whom? Who is appearing for the DC? You are appearing for whom?
Proforma respondent number
Respond number 4. Who is he?
Lordship Rajan.
He is the
Number 4. Why are you making this respond number 4 a party? Kumar Parikshit Narayan Dev. Who is he?
he is a father-in-law and he is a brother of the representative. He is running.
So, are you asking any amount from him?
No.
You are not asking any amount from the chief engineer also.
Now, I'm asking for the amount of the chief engineer because he is the rent. He is the rent of the page 30.
Yes, madam. What is this?
We have written to the deputy commissioner.
Uh,
Failed to list any response.
no response.
No response for 18/12/23. We written,
My,
along with a copy of this order, the order dated 15/12.
then
No response.
which deputy commissioner is this? Oh, nearby.
Metro.
We will get him.
Metro.
We'll get him. We'll ask him to be present in court.
Yes, Ballard.
Or
It
submit
may
a
be disposed of. Let them examine.
No, this type of examination they will delay. We want the money. Give it to him. They vacated it.
Yes.
We want the date on which we are going to pay the money. Then only we will find out whether you are paying in installment or anything. This court, by an order dated 15/12/2023, had sought for instructions from the respondent authorities and more particularly the Deputy Commissioner, Kamrup Metropolitan District, as to whether the respondent authorities had occupied the landed properties of the petitioner for the period from 1/2/2010 to 31/8/2015, and if occupied, as to whether monthly rent already assessed have been paid to the petitioner for that said period. Ms. S. Sharma, the learned counsel appearing on behalf of the respondent number 2, has submitted that this order dated 15/12/2023 was duly communicated to the Deputy Commissioner, Kamrup Metro. However, there has been no instructions. The said aspect of the matter, in spite of being communicated, clearly shows that the action on the part of the Deputy Commissioner, Kamrup Metro, prima facie, is not aiding towards the interest of justice. Taking into account the above, this court fixes the matter again on 12th of January 2024 at 10:15 a.m. on which date the Deputy Commissioner Kamrup Metro shall be present before the shall appear through video link so provided by Mrs. S. Sharma along with the instructions. It is made clear that if the Deputy Commissioner is not present at 10:15, providing the instructions, he shall be personally present at 2 p.m. in the court.
Of the properties of the petitioner by the respondent while under the PMLA Act. And the properties has been attached by the virtue of an order dated by 12/2/2018. That was a challenged order by
What happened on 16/11/2023? The matter didn't come.
did not reach my last petition.
No, I directed them to produce the record.
Yes, that is the other difference.
While passing the interim order, it was pleased to observe that there is no reason for it recorded by the authority in the attachment order. That reason to believe that order dated by
You are challenging the order dated 24/6/2020.
that the order is 24/6/2020.
So there was a stay out there.
Yes, my lord.
What happened thereafter? Did you proceed in terms with section 5(1)(ab)?
No, my lord, because of the order.
No, they was made clear. However, it is clarified that the interim order shall not preclude the respondent authorities from proceeding against the petitioner under the provisions of section 5(1)(a)(b), if so advised by following the procedure prescribed in the proviso to section 5(1).
Yep.
You have not done. Okay.
because of it. And also, my trial has been paid under section 45 of PMLA.
Let's see section 5(1).
That not been changed.
Section
Already,
5.
my lord, thereafter, my lord, the complaint has been initiated in fact. Now the whole subject matter for the fact.
Section 5, madam, attachment of the property involved in money laundering.
Let's see whether the reasons were recorded or not.
Yes.
Now, has the adjudicating authority done anything?
No, but
Why?
madam, because initially that has been stayed by the release court, and we have also filed that interlocutory appeal for vacation of stay, madam, that has been rejected, madam.
Because the provisional attachment order was for 180 days.
Yes, madam.
What happened thereafter?
Thereafter, madam, yeah, it is, madam, case number, section.
The interim order was passed from
Section
10/9/2020,
Yes, madam.
almost 180, 90 days thereafter.
Yes, madam, 109.
Then what happened with it? Does the this provisional attachment order, does it remain any further?
That is upon the adjudicating authority, madam, because madam, kindly.
No, madam, kindly understand.
Yes.
A provisional attachment order is for 180 days.
Yes, sir, that is,
Have you extended it?
no,
If you have not extended, has it not spent its force? Wrongly, rightly, it has spent its force. Then what remains to be decided now? If you have not extended it.
I'll take it whether it is accepted or.
It will
Yes,
be
sir.
here in the records,
Yes,
it will
Record
be
is there.
such a big file, I think it will be there.
Yes. I'll take.
Or is it because the matter was pending before this court, you have not extended it?
That may be.
Or there was a stay for which?
But it is.
However, the issue involved out here is as to whether the reasons to be recorded has to be put in the notice
Yes.
order
Yes,
of attachment. That is the issue.
that is the.
That is an issue, but is it an issue to be decided in this case when the provisional attachment order no longer survives? We can spend that time on some other better matter. You have obviously not extended it because the
yes.
order was stayed.
Uh, Malad, concern officer is in Aizawl now. He will come on Monday. Malad, Tuesday better make it taken. Malad, that he will.
But one thing is very clear.
Yes, Malad, that I.
That when there is an order of stay, the question of extension of an order
Of
which
course,
is
yes,
state cannot excite.
Yes.
So you couldn't have accepted.
Yes.
But on the other hand,
One
as
is
of
days it
now,
become-
we take it after 4 years.
Yes.
So
Yes.
180 days is long past.
Yes, Malad, that is. I'll go through it, Malad. What is the provision after if the after Malad 180 days, Malad, that is 180 days, Malad, after expiry of 180 days. What will
Because you see, otherwise, my opinion, he doesn't have a case.
yes, Malad, yes,
See, these reasons to be recorded,
yes,
reasons of belief, reasons of belief and reasons to be recorded.
yes,
If you see the judgment of the Supreme Court, I think in 1967, the Supreme Court in the case of income tax court,
yes, Malad, I have that.
you have that
Yes, I have.
S. Satyanarayana.
Yes, Malad, I-
Yes. So there the Supreme Court categorically says that the reasons are not to be given.
yes, Malad.
However, later on in a recent judgment out here in JK and Drive Shack, the Supreme Court says that yes, the reasons if you want, you can very well apply and file your objections to that.
Yes. And Madam, alternative image is available in that.
Understood. So
Yes,
these are aspects. I'm with you on that aspect.
Yes,
But the fact is,
What is the 180
but
days?
would it be necessary for me to write a long judgment on this aspect when they otherwise the patient have already
Correct.
patient has already been discharged.
But I'll
Okay.
I'll
Is the
check
matter
it on
again on Tuesday next on 9th.
Tuesday.
On which date we take at the letter council appearing on behalf of the central government, on behalf of the
PM, sending us a PM. ED, my lord.
standing out, Mr. Tika, standing
ED.
PMLA shall apprise court as whether the order of future assessment attachment dated 24/6/2020 have been extended beyond the period of 180 days. Otherwise, Mr. Bora, what is this exercise to be done? They have not extended it, matter there's already been.
That's why that order is there. That the second part, the option is still available. When because the complaint has already been filed before the trial. So the 5(1) is still applicable.
They have not done it, that is their lookout. But as of now,
As of
if
now,
the
it's-
provisional attachment was only for 180 days,
Yes, sir.
why should I look beyond that? Now, three and a half years
Three
have
and a half
gone by. Makes no sense for this court. Matter has already become redundant. You can very well, you have been given the opportunity to avail the remedies of the 5(1) to which you have. So you have a case.
Yes,
But
but
then, as of that day, the matter was have been taken by me. I would have decided like now. 60 on 12, huh? When?
12 no, but
9.
Item 27.
Interim maybe.
Yes.
My lord, before my learned friend discussed, I mentioned this matter at evening, and this is the
What happened
order of another court.
Huh?
This is the order.
You got the order there.
No,
It was item number 20.
27.
There.
There are petitioners here, but in this case, all of These petitioners are private respondents. So order may be seen dated 19/12/23. So our limited prayer is this, or both these two matters may be listed together in the same court.
What order did you get? That is on 1912.
Yes,
That is on out there. It was picked on 3/1/2024.
with
Yeah.
with WBC
What
number.
happened today in the other matter?
Well,
There's another matter in court number 12.
Yes.
What happened there?
No, that court said that first you go to court number 17, and what order passes, then you come to us. This is the
Oh yes. Now let us see what is the order to be passed here.
1912.
Yes, so far my petition is concerned, my lord. It's regarding my these petitioners are, my lord, they have been displaced because of river erosion, and they were given alternative site in a village breathing reserve. Then, my lord, that is act of the government. That is in my lord 1967. That my lord, that land should be converted, that it should be allocated. Nothing has happened. It has- But there is no occupation of the land. It has happened now, my lord, after the allotment to the premium there. That- So at that stage, my lord, this converted for me. Now, I don't know about the other case, my perhaps my client have not been served with the notices, otherwise I would
No,
know.
no, notice
Anyway, my lord, I will not have any objection to that, but then I'd like to have the case number. Or my friend could give me a copy.
Just about the case. Just about the case.
This case of the affidavit would be necessary for the record.
Now you are in which you are in the Gugubari village grazing reserve.
Yes.
Now you will be given settlement somewhere else.
No, my lord, there is.
How?
Sanction has been given, if your lordship kindly come through, page 19, my lord, page 20.
Huh?
Original copy. The government has already sanctioned. I am directed to convey the sanction of the governor of Assam to the reservation of the land measuring 240 acres from Gugubari village grazing reserve of
That was done in 1971, but till date they have not done it.
there have been many complications.
Then
Subsequent complications, the latest is my lord, is 26, where the Mohdadar has submitted the list of allottees.
Hmm.
And prior to it, my lord, there has been complications.
yes, Mr. Hendrik.
Correct.
What is this? You are going to give as of now, if you have not done it, how do you do so in view of your land policy? Understood. As per your new land policy, how do you de-reserve now? As of now, too, it cannot be done. Huh?
They have stated it is a busier land, so it cannot be allocated to the other petitioner.
Unless you de-reserve it. Now, whether the government is in, are you going to de-reserve it? No, because you have already, there is some note
Not mentioned in the market.
there, huh?
Not
Get
in-
your instruction on page 20 of the
not-
petition.
I have seen the whole.
This is 1971. At that time, Jakpal Singh and all these things, judgments were not before.
No, no.
So at that point of time, it could have been done. Now, can you do this vizia, de-reserve? De-reservation nowadays is not. And more particularly in for your land policy, it will be difficult. But anyways, you file your affidavit. Huh? You file an affidavit. Or find out where these people can be, because they have been residing out there for more than 46, 47 years. They are- So they may have to file applications now if necessary. They have to file application and then you have to give them in some other place if you are not de-reserving as per this. Although this was given at that point of time, it was given in 1967, 71. Okay, list the matter again on 5th of February. 5th of February on full stop. The standing counsel appearing on behalf of the Deputy Commissioner Kamrup as well as the Revenue Department, Mr. J. Hendik and Ms. P.R. Mohanto, respective, shall ensure filing of the affidavits. So further to that, it is also directed the state authorities are also directed to indicate in the affidavit as regards what steps have been taken pursuant to the office note dated 10 to 11 to 1971.
Government state
Huh?
The date is my doubt,
11 to 1971.
11 to 1971 was a note, my doubt. By the government sanction is my doubt, 21st of March.
Pursuant to the letter, the government order, here, please answer this discussion between you. But as regards annexure 1, page 20, where 19 and 20 of the resolution.
Along with that WPC.
List the matter along with WPC number
7370
7370 of 2023.
on 5th February.
I've already mentioned. Because your case is, you are actually there.
Yes, we are already there. We are in possession. Our position has been also substantiated by London District Judge also.
Very well. So give a copy to him,
Definitely, I will give.
Mr. Sharma.
Now already order has been given.
Then give a copy to him.
Yes,
He will also
definitely.
know what you are.
Yes, no.
Give a copy. I'm not putting it in the order because as of now he is not.
No,
So let him also know.
Definitely we will serve.
Yeah.
Did you go? Number 2.
We are it up to-
Huh?
it up to-
You are newly engaged. When?
I submitted.
You filed your affidavit today only.
Wakalat, they have.
We need time.
Mr. Kolta, what is the matter about?
Also, it's regarding CCF, like Central Capital Investment Subsidy.
Hmm.
So, I mean, they have been registered and they have applied for it. But like when the spot verification was made, then like miscellaneous were not there. Partially it was, it was commission and partially it was not. So that's why it was not recommended by the GM. So it was not placed before the SLC. That was the case. They have challenged this. Because though they have stated that they have done commercial, they have already started commercial operation,
Hmm.
but the machineries were not installed when the spot verification was. So that was the report of the
This
GM.
is pertaining to what?
Central Capital Investment Subsidy.
Investment subsidy.
Yes.
But you have given the other incentive?
No, they have applied for only the capital investment subsidy.
So you have not given them anything.
But they have applied for this, so they have been registered, so they have applied. Actually, they wanted to go for substantial expansion.
Hmm.
So for the substantial expansion, they have applied for the CCI scheme. So when they have applied, they have given their date as commercial date of operation in 2016. Then on 2017 or 18, the spot verification was done when the application was made for availing this under this scheme. The spot verification, when they went to the spot, that GM found that this, this shade was not properly done, machineries were not properly installed.
Understood. All these things are understood.
Correct,
I got your point on that.
Correct, correct.
I'm not saying on that.
Correct, correct.
Now they have applied under what? Which scheme? 2017?
2007 scheme.
2007.
7.
Now, while applying for 2007,
Right.
they have not only applied only for the central investment subsidy.
Central
They must have also asked for the central excise.
that I don't know. I don't have that. I do not know because they haven't stated.
No,
anything.
you have not issued any eligibility certificate.
No eligible certificate. We have
What have you issued?
only they are registered EM certificate, entrepreneurs memorandum certificate. That is all. That is required for getting the subsidies or benefits under the NEI.
Let us see their certificate to the.
Lordship will find it page 15, Lord. There is certificate of issuance EM part 2. Then 70, Lordship will find that certificate of registration under any IPV 2007. Eligibility certificate will be required only when they ask for themselves to they go for this tax benefits.
Hello. Miss Swenso appearing on behalf of, what's your name? Appearing on behalf of the petitioner submits that they have been recently engaged in the matter for which seeks for a further 2 weeks' time for filing the affidavit in reply. To list the matter again on 12th of February 2024.
God bless.
Orders me. Yes, what are these?
Item, Lordship, the special writ applications,
Okay,
Lordship, so far as 29 is concerned, we have filed a Lordship IA today. And Lordship, so far as item number 30 and 33 is concerned, Lordship, the hearing is going on for special writ. The hearing is going on for item number 30 and 33. There are 3-4 items which has come together, Lordship.
Which one?
Lordship, item number 30 and 33, Lordship, the hearing is going on. Special writ application, the hearing is on. It may be concluded within 2 to 3 weeks. The special writ application, Lordship. We had filed a petition before this honorable court. The special writ applications are pending. So, Lordship, item number 30 and 33, Lordship, the Lordship hearing is going on. Lordship, 30 and 34. The 30 and 34.
No, this case.
So far as this case is concerned, Lordship, what had happened, we have filed Lordship, we have already filed a special writ application, but maybe it was missing in the petition. So, Lordship, but we have pressed the petition, we have filed an IA, Lordship. Today we have filed an IA, enclosing the entire, because the interim order was vacated on the last occasion, only because the special writ applications, we have already approached the authorities to trace the applications that we had filed. They were not able to trace it. Now we have given a receipt copy to them, so they are also tracing. And Lordship, we have given a receipt copy, Lordship, along with the IA today we have filed. So, Lordship, that will also be, we are approaching the department for that. Lordship. We have already approached the department also for that, Lordship.
When?
Lordship, we are approaching the department because the receipt copy, we have given a copy to them. But I have filed an IA in this respect, so IA will be, Lordship, the IA will come on record, Lordship.
Yes.
30, 31, 30, 34, 30, 29, 30,
34 and 36.
Lordship, all these matters, Lordship, the speeches, so far as 30 and 34 is concerned, At least Lordship, we
Let
are-
us not jump to 30 and 34. Let us now stick to this item number 29.
there we have.
29 is a case that you have not enclosed any document to that effect.
Lordship, I have.
Now you say that what about the document? So I have vacated the interim order.
Today they have filed an affidavit
We have filed Lordship.
annexing some document
Ah.
that they filed an application in 2020.
That document application is not
Today we have been substituted.
okay.
And in one case, Lordship, item 30, the same petitioner, they have not submitted the entire document, although they have filed application, but entire document to consider their special rate. Documents are looking for.
The hearing is going on, but we will submit.
That's a
before the
different
authority.
thing, but in this case, there was no application.
Yes, it was not.
Lordship, I have filed I have filed the receipt copy along
We
with that.
gave you a number of occasions why you have.
Lordship, at that point of time, Lordship, I'm really sorry because there was personal difficulty, owing to which I'm really sorry that at that point of time, I have
I
explained
gave
the
you many
difficulty.
opportunities.
I have given the, I have explained the Lordship, the difficulty which I faced at that point of time with the IA Lordship. Whenever the IA will come up, Lordship,
Now you have filed an affidavit. Where is it?
we have filed it today, Lordship, that it is not on record, so Lordship may come up, Lordship, after due vacation, it will come up along with the affidavit so that it can be heard together.
But the interim order has been vacated.
Lordship,
Do
they are
whatever
not
you
taking
like.
any action.
Huh?
They are not taking any action because
Okay,
we have given
take
a receipt to them.
Take it.
Lordship, we have given a receipt to them.
No. First of all, why did you obtain an interim order without enclosing that representation?
Lordship, the representation was there. There was some mistake. Lordship.
No, there can't be any mistake. Why on earth? Because the court out there at the time of passing of the order was under impression that there was a representation submitted, but that is not a part of here. Then
Lordship,
why have you done that?
Lordship, over there, Lordship, while filing the Lordship, there was a mistake because instead of special lit application, an order was annexed, Lordship, instead of that. So that will also be sure to so that the applications were filed. But instead of that, the order was expressed.
The
Lordship,
court
this
was
is-
this court was misled at the time of passing of the interim order. When the matter came up before this court, only this court noticed it. Anyway, this is the matter on 19th of February 2024. The request of the learned counsel appearing on behalf.
Item of 30 and 30, Lordship, the 34, the hearing is going.
Wait. Now 30 is yours.
That is the same petitioner. In this case, Lordship, but they have not submitted the entire documents to consider their application for a special rate.
Huh?
Application has been annexed, but while considering the matter, the department found that some documents are not there to consider that application.
Then
they have to submit all the documents. Lordship. Then it will be
before
the
authority.
authority.
So they have filed the application.
Yes, they have filed it. It is annexed with the application.
Ms. M. Haveli, the learned counsel appearing on behalf of the petitioner, submits that the hearing in respect to the application so submitted before the authorities for special rate is presently being taken up by the respondent authority. Mr. S.C. Kyle, the learned counsel appearing on behalf of the respondent, submit that the petitioner have not placed the relevant documents, various documents which have been sought. Taking into account the above, this court fixes the matter again on 19th of February 2024. In the meantime, the learned counsels appearing on behalf of the parties are directed to apprise this court as regards the outcome of the said hearing proceedings.
But it should be on 23rd. So by that time, most probably the 23rd.
Why?
Lordship, because the hearing is going on and some papers we are collecting, Lordship, they will be due vacation. By 23rd, most probably, Lordship.
I'm picking on February. On February, 19th of February. Yes, what is your case?
Lordship,
Non-payment.
non-payment of contractor fees, my lord.
Some payment has been made for the remaining 2,71,000.
You are entitled to get 2,71,420.
Lordship.
Okay.
As per my instruction, my lord, the process for release of the payment is going on. That's why I pray for 10 days time.
You are going to make the payment.
Lordship, I will have to the clear instruction.
Huh?
10 days time will be granted
For what?
for clear instruction about the payment of the amount. Process has already been initiated.
The learned counsel appearing on behalf of the missing autonomous council submits that the process for payment of the amount to which the petitioner is entitled to is being taken up, has already been initiated, and as such seeks for an accommodation of 10 days to apprise the status. This is the matter again on 29th of January 2024, on which date the Miss So-and-so, the learned counsel appearing on behalf of the missing autonomous council shall apprise as regards the status.
Of
Yes, what is this
Hello, sir. We have filed the affidavit, my lord, for
regarding
ex gratia, my lord.
ex gratia?
My lord, it's a, my lord,
Ex gratia for what?
for my lord, the petitioner's husband has died, my lord, due to drowning, my lord, in the flood. They have stated in the flood, but as per the report of circle officer, my lord, we have annexed in our, my lord, affidavit, page 38, my lord. On that day, my lord, there is no rain, my
Huh?
no flood,
Drowning?
my lord. Yes, my lord.
Drowning in flood water.
My lord, that is not correct, my lord.
As per you, what is it correct?
My lord, on that day, my lord, it was not, my lord. There was no flood, my lord. To page 38 of our affidavit, my lord, we have enclosed the daily flood report by circle officer.
So there was no flood.
No flood.
How did he die?
That, my lord, information is not clear.
When did he die?
18/6/2020.
18/6/2020. There is no flood.
Yes, Lordship, as per the affidavit, there is no flood.
Then what to
As
do?
per Aberdeen
You
Medical
died somewhere.
Police report, your Lordship,
Huh?
clearly mentioned.
Is it something which we hear out there? In Hindi, Turu mein pani mein dhupiya, is it something like that?
Your Lordship.
Huh? How did you die without the flood?
Okay. Due to, as per police report and postmortem report, the
Postmortem report cannot say that you drowned out of floods. It will say that you have you drowned.
Yes, sir.
That may be a thing, the postmortem report.
Yes, sir.
And let us see the police report. Does it say that it is flood?
In the
Yes.
police report, they have
At
said.
best 23 years. At best 23 meters per second. During investigation, it has come to light that the disease of blue dust, a so-and-so, so-and-so, son of so-and-so, died
Yes.
due to drowning in flood.
Which is the officer in charge of Borpeta police station a party to the instant
Yes,
proceeding?
Lordship.
Yes. Who is appearing for that?
Complaint number 5.
I'm appearing on.
Okay, madam, file an affidavit now, clarifying the different stand.
My lord, my lord.
From a perusal of the affidavit in opposition filed by the respondent number 3, and more particularly the enclosed and annexure enclosed thereto, reveals a totally contrary picture which have been given by the officer in charge of Borpeta Road PS, which is annexure 3 to the petition. The officer in charge of the Borpeta Road Police Station is the respondent number 5 in the instant petition. He is directed to file an affidavit clarifying his stand in respect to the above issue, in respect to his report. List the matter again on 7th of February 2024.
Obliged.
33.
None has appeared on behalf of the petitioner on call. It also is apparent from a perusal of the records that the petitioner have not been represented on 3 earlier occasions. It seems that the petitioner has lost interest in the instant writ petition, for which the instant writ petition sends dismissed for non-prosecution. Ek minute. Same type. Eight item dun to 30.
29 and 30.
No, not 29. 29 is 30.
30.
Itu 30 lalu itu same type. Beleg also same. 9. Here also he has not given all the papers.
Here Lordship, I have not restriction, but it is under consideration.
Yet itu A line to दूसरा रिवर. ये paper and idea बोली itu दूसरा रिवर. ठीक है, submit करছে all papers. Okay. Itu
35 and
But what has happened? This is relating to income tax for the assessment year 2017-18. But if we challenge this order on the ground, the notices which they have sent, we challenged it on the ground that they are barred by limitation. 148. But if first, initially we challenged this notice in the first case, that is Lordship item number 35, Lordship 2017-18 148 notice. Thereafter, Lordship, even though
17-18, what is the time?
Lordship, the
4 years. 4 years is from 2021.
Lordship, the
22.
As per the Lordship, there was an amendment in the Lordship Finance by a Finance Act. There was an amendment in section 148. Now they have reduced it to 3 years. So if in case there is a Lordship suppression by the assessee, there is 148 there in by way of section 1 in section of section 149. If Lordship there is a suppression by the SSC, then it is extended up to 10 years. Earlier it was 8 years. And Lordship, if there is no suppression within 3 years, the notice has to be sent.
3 or 4?
Lordship, earlier it was 4 years, now it is 3 years after
When?
the amendment.
When did it start?
Lordship,
2017-18? What was the period?
Lordship,
When did you get the notice?
And on 31/3/2018, and 3 years is completed on 31/3/2021.
But that was the period.
Yes.
When was the notice issued?
Lordship, the first notice which was under section 148 in the first petition was issued to me on 30/6/2021. Now, Lordship, they substantiated.
So what was the what was 149 at that point of time?
Lordship, at that point of time, Lordship, the 149 is provided for when 36/2021, when the notice was given. Till that time, the new Lordship law had come into Lordship picture, and till that time, the 3 years period had come. Otherwise, Lordship, there was 4 years, then that would have been on time. But on 36/2021, the Finance Act had Lordship there were amendments in section 149. So the maximum period was 3 years. In case of Lordship, when we have suppressed the material, we have not suppressed, and in case we have suppressed, then it is extended to 10 years. So if we fall under B, then it is Lordship 10 years.
Let us see what is your. Let's see the notice.
Lordship, the notice is on page 87.
Page
87. In the first petition.
Dr. May kindly see the another blocks, pen number is given, thereafter assessment year is given, that is 2017-18, and the date of the notice is 36/2021.
Let's see the income tax act.
Section 140. Time limit for notice.
So, where is your question of fraud?
Lordship,
149B, what does it say?
if 3 years but not more than 10 years have elapsed from the end of the return, unless the assessing officer has in his possession books of account or other documents or evidence which reveal that the income chargeable to tax represented the form of asset, assessment, or is likely to amount to 50 lakh rupees or more for that year. Lordship,
Oh,
what had happened?
It's not on the question of fraud.
Lordship, but our Lordship case will fall under 149A. Lordship, I'll explain. Lordship, firstly, Lordship, I'll just show that this notice which was sent, which should have been issued, they took the plea that under provisions of section A, they issued it in old provisions, taking the plea that 4 years is still there, not 3 years, and therefore they had issued this notice. Lordship, this they had issued because they said that the old provision is still applicable by way of notifications which are annexed at page 96. Those notifications which are annexed 27 to 20, there are 3 notifications which were issued.
Yes.
There was 3 notifications. That one was on 27th February. Second was on 31st March.
Where the specified act in the income tax hearing of the month that the completion of any actions under one of the 31st March shall be. Well, the explanation.
Lordship, yes, your Lordship. So by way of 27th April 2021, the last notification, they have extended the date till Lordship 30th of June. So they have issued on 30th June, so they had taken the plea that we had.
Now, what
given-
do you say at page 99? The explanation.
Lordship, in fact, this all these notifications, they whatever they had explained, we had challenged these notifications that these notifications which are issued under the section 3(1) of the Taxation and Other Laws Relaxation Act. Lordship, these are not valid Lordship notifications. But these were subject matter of challenge before the Supreme Court, by which they have extended. The Supreme Court, by way of a judgment, said that yes, they are not taken. These notifications are not correct, but they had allowed the respondent authorities to complete the assessment. Even though this has been done, these notifications are not incorrect. They could not have extended the time limit for Lordship for the old law to extend till 36/2021. They could not have done it. But still, Lordship, the Supreme Court said that in the interest of justice, I allow the respondent authorities to complete the assessment. But the Supreme Court judgment is there.
Then what to do?
Ashish Agrawal. Lordship, in the second petition, I have annexed that question. Lordship, this is relating to after that, Lordship. Page 92, the judge is there. Page 122, if you Lordship, see paragraph 10. Because Lordship, in many of the states, the notices were set aside. So
Okay. Now, in view of this, what has happened?
Lordship, after this judgment was pronounced by the Supreme Court, Lordship, they had again issued me a notice under section 148. Lordship, which was subject matter of challenge before this honorable court. I had challenged and I had said that they have not followed the proceedings and the notice is still time barred. That was my subject matter of challenge. There was a stay, Lordship. But in the meantime, when the stay was operating, Lordship, the court has said that no coercive measure may be taken. Lordship, they have passed the adjudication order against me. Assessment order has already been passed. In the meantime, I have filed 3 IAs. I have seen that it has not come on record. They have all the 3 IAs have passed, Lordship, with the last year summer itself. They have passed the assessment order and they have started recovery process against me, violating the orders of this. That is why, Lordship, I have filed some IAs. There was an interim order. Lordship, you kindly see that interim order is operating in this case.
So your first petition has become infructuous.
Lordship, Lordship, even though it has become infructuous, but my second writ petition is connected with the first writ petition. I'm saying that if Ashish Agrawal has to be read in whole, Lordship, that it does not apply to the assessment at 2017-18. That is my only ground.
Huh?
Not to 2017-18, but 17-18, Lordship, so far as 17-18 is concerned. Lordship, it was expired. The time period was expired. So far as other assessment years was, Lordship, this was the case where they did not follow the Ashish Agrawal has given them the power to do it because they did not follow the new provisions. they followed the old provision and send the notice immediately. But there are some preconditions that before issuing notice,
148A.
148A has to be followed. That they did not do. So the Ashish Agarwal is on that pretext. My case was different. I am talking about the, I was talking about that the 2017 at the time period has expired. So that needed to be lordship addressed to. Ashish Agarwal is on different footing, and taking the plea of Ashish Agarwal, they have issued again another notice. So that is what I have challenged before this honorable.
Now, what is the amount for reassessment? How much it has escaped reassessment?
Lordship, it is more than 50.
Then B comes in. Matter in
1 crore.
More than 1 crore.
Couldn't B come in?
1 crore 75 lakhs.
Huh? So then
1 crore 75
B steps in.
Lordship, Lordship, I will explain it, Lordship, that IAs come into, IAs may also.
I will look into it. It is for 6 weeks. There is no date fix. Does it continue thereafter?
Lordship, in fact, I should be very honest, Lordship, this was the first day of the court. I did not read, but Lordship, there is a reason for which I am telling that this part by limitation, I filed the petition.
Understood, but if it is 1 lakh, 1 crore 47 lakhs has escaped assessment,
Yes, sir.
why wouldn't 149 1B will apply? Forget about the other aspects. Let's not go to Ashish Agarwal and all this. You issued notice under 148A thereafter.
Yes, Lord.
Yes, sir. They had followed that one. That was also Lordship of
148
LSI.
148 B.
But at that point in time, this matter was pending before the Supreme Court. So we informed them that we did not rely on merit. We said that this matter is pending before the Supreme Court. That is before decision. Thereafter, you come for this. But Lordship, they did not.
Again, the problem will arise. No, here there is no coercive measures. The problem is the order has to be, the proceedings has to be suspended. Unless it is not suspended, they would again be barred. You see, there is a provision out here, there is a proviso out here, whereby the period of limitation is being extended if there is a provision of stay.
Yes.
The stay is not here. Here, the order is no coercive measures.
In that case, they will be having.
How do you take care of that? You have to think about the revenue.
In that case,
You were once a standing counsel of the IT department. Now tell me, standing on the shoes of the IT department, how will the IT department later on say, then look here, this is the state of affairs.
in that case, they have 10 years. In that case,
So
if they are saying that no, we go under B, then they have 10 years.
do they know that the matter would be finished off so soon?
But they could have filed an application before the honorable court stating that we will be completing assessment, but we are
The
telling them
completing of assessment is not coercive measures.
Yes, sir.
But if they have
And that is their
Completing of assessment is not coercive measures. The assessment can be very well completed, but the only thing is that
activity, that
no
cannot be-
coercive measures would be meaning that your properties is not attached and all these things is not there.
they have sent recovery notice.
The notice is also not coercive measures. Now, have they taken out here that your properties are attached? No, they have not taken that recourse. That is no coercive measures. If we say that no coercive measures, that means you have to be pinched. You're not pinched.
Lordship, passing of an assessment order against me is also Lordship.
Absolutely no. Absolutely no. That is the biggest problem. If you pass orders in these type of matters of no coercive measures, it will have far-reaching consequences. Anyways, your eyes are there. We will take it up on some other date. But your issue is once the reassessment has been done out there, which comes to 148, 1 crore something, then how does the 3 years limitation at all comes in? And we are to also look into the reasons.
Yes, sir.
The reasons are not there. Now the reasons has to be also seen out there as to how it is to be done.
I'll obtain the report.
Yeah, because then the question will arise. Now, another aspect will be, one is the question of limitation. Then how do you take care of 148A coming into picture?
What's the date?
148A was there prior to 1989.
Yes.
After 1989, you don't have 148A. 148A again comes into picture in 2021. So how do you take care of a particular provision coming into? Limitation is okay, which is being taken care of by those notifications. But how do you take care of 148A?
That we have actually in our first case, we file a affidavit and we explain to that.
Very good. We'll have it on 6th of February.
Lots.
This is the matter on 6th of February for final disposal.
On 6th of
By
February,
admission.
I'm out of station, Lordship. Lordship,
What?
Lordship, 12th of February, 12th or 13th, Lordship.
12 pairs the other matters.
13th,
Seven. 5th or 7th.
But 8. But
8
I'm
is
out-
not possible. 8 is close,
I am
or
out of
8 of February.
I'm out of India, Lordship.
8th of February. For final disposal.
But
The learned counsel for the petitioner has submitted that there are some interlocutory applications which have been filed. The registry shall bring on record such interlocutory applications. 40 order.
That matter, mother eviction. 2014.
Yes. Along with the records of WPC number की बात आई थी नहीं?
Yes, that writ petition has been disposed of.
Hmm?
The writ petition, both the writ petition was disposed of. Setting aside the notice. Your lordship's order, my lord, 20th January 2022.
Where is the order?
My lord, this order, my lord.
What is he asking for here?
Actually, my lord, what happened? The petitioner was allotted a land, my lord, 2 hours in the Polton Bazaar area. Within that, my lord, flood, my lord, block area and water. And there is 92, some land was allotted and 95 that was cancelled as per record. So when there is a my lord, flood in the Guwahati city, there is a my lord, they have taken a drive to free the Guwahati my lord, water mission. So under the my lord, 2008.
Why dispose it of?
Yes, dispose of all the now. Question is, my lord, there are interim order not to big, but
it is different. The petitioner was allotted a land.
yes, allotted 92, 2R, and 1995 what my lord, that was cancelled, and we record is there. And cancel record is not, thereafter the petitioner moved to petition. Before this honorable court, that the notice is, my lord, is a paternal land, notice is, my lord, illegal. That was set aside. That order was also, my lord, record was not corrected. And thereafter, again, my lord, notice was issued by the, my lord, authority, deputy commissioner, my lord, under section 18. My lord, then what happened? They have come before your lordship 267, not to evict. And then court has gonna pass an interim order not to evict. That is over. And that is the order that was not brought to the notice of the evicting official. The evicting officer is a mission flood free Guwahati project flood. Under he was doing it. Dear Bahini, this Nodim river malot, the Polton Bazaar, the congested area. Then that was evicted. So many persons are there, malot, not only the petitioner. And now, malot, what happened? Petitioner now in the position. He is malot has taken the land malot and living there, erecting a house and around the wall. So she is getting the question. The question only arises, her building is demolished. Now that is the separate issue, Malan. Building is demolished, Malan.
Who demolished?
Her building is demolished, Malan, which is part in the Malan water mission report project. So that is building is mission. Otherwise, the plot land is Malan possessed by the petition.
Who demolished it?
Malan,
Who demolished it?
that is the ADC. Malan.
Okay. So is the ADC a party here?
A party here, Malan. I am appealing for him, Malan.
So let him pay the compensation to.
Compensation, that is the is schedule file a separate petition, Malan, because for
Not
compensation.
necessary. Why? In spite of the order passed by this court, in spite of the order passed by this court, how can these authorities take up the law in their hands?
That
The
is
way
true, but
seriously-
that notice was not brought to the place. Only the eviction was done as per records of the Malot. Let's kindly see the record. As per records of the Malot, that is under the Malot, it is cancelled and it is under the Malot is revert. This Malot Sita copy, my lord.
No, Mr. Zutia, the first fact is, this order was passed by this court on
2014.
4/6/2014
Yes, my lord.
in presence of the respondent. More particularly, Miss H.M. Pukon, the learned government advocate, accepts notice. So, if she has not communicated, when the lawyer is very much present and the authorities are not being communicated, that is not the fault of the petitioner.
That was not done, my lord. That was. not,
Then obviously,
So
if
the-
H.M. Pukon doesn't, you take up action against H.M. Pukon, do whatever you like, but you have to pay this amount.
The evicting officer.
How much cost?
Evicting officer, my lord.
Lordship, I have given the photograph, the entire structure was demolished. Even I am having at the time of demolition, the concerned, the ADC was shown the order of the honorable court.
Yes.
They have also the permission, the building permission, because I got the
And,
building
uh,
permission
this
and
is not
accordingly
done.
the structure was erected. And that entire structure was demolished by using
Not,
the photograph.
this is a very serious thing.
Kindly see the
Where
condition.
the photographs? I saw some photographs
Yes,
here.
Lordship, this page number 3031. I have given the entire structure.
31.
The entire structure was brought down. Hard-earned money, the construction was made and the building was demolished. Page number 3031 also the contemplation.
You have broken down the house. Couldn't have done. Have you filed any writ subsequently?
No, Lord,
How do you assess the compensation?
that I have not.
Punishment is one aspect, but would the punishment suffice for you?
Compensation part is there, that I have filed. Contemplating on that. So the order has been very recently, the order has been passed. Contemplating the final application, the writ petition. In that view of the matter, Lordship, this structure is there and it is the admitted position. In spite of the stay order, Lordship, is entire structure.
Huh?
In spite of the stay order of honorable court, the order was passed in 4/6.
This is absolute high-handedness. Who is the person concerned?
My lord,
Let him be personally present in the court so that I can pass the sentence in his presence.
lordship kindly before.
What is his name?
Lordship kindly see.
Mr. D.M. Angamatu.
After 7 years, Lordship, the affidavit was filed.
The
Last
affidavit
location.
was per we delayed.
Mr. T.C. Sutia, kindly do one thing. Advise your client to settle up with the petition.
No, my
Do
lord,
something.
I
No,
am-
no. I'm not going to listen to all these things. You settle up with the petitioner. Because this court is not, this is absolute high-handedness. When there is an order being passed by this court, this is not being followed, and you break a person's house.
My lord, what I want to suggested, my lord, I advise my client because he is no more here in ADC or circle officer. He is
Forget
just-
about whether he is
But
there
he
or it is his
requested.
personal response
No,
or the
that's why-
government. Let the government take a
Sir,
decision, whatever may
I
be.
request the petitioner also, my friend also requested you please back the present deputy commissioner as a party, then it will be implemented.
Deputy Commissioner was
No,
not there.
Implement what?
For Malad,
No, this is not a case of implementation.
no,
It is a case of violation.
violation there has been done, my
You
lord.
see, implementation of an order which has been passed at that point of time is a different aspect of the matter. That I direct that let him be paid the amount or compensation should be paid out there. That is a case of implementation. Here is a case of direct violation of the court's order. And it is, you can't make other people out a party. Here, these are the people, these three, Yanandra Dev Tripathi, Mr. M. Angamatu and Mr. Lakshminandan Sohoria. These three persons are absolutely liable.
No, my lord, before that, my lord, what-
I appear for Janendra Tripathi Lordship.
Yes.
He has joined the previous day Lordship and demolition was done the next day. It was not even that has been recorded in Lordship. Of course, Soda also Lordship. 26/5/2015.
Huh?
26/5 to in this contact is 26/5/2015. I had it recorded. Lordship.
in fact, my lord, respond number 3.
26/5/2015.
There's no 26.5, 29.5.
It's, I have it here.
Which one?
First, top one, 26/5/2015.
No, who was the officer concerned? This was the deputy commissioner and he may not be much aware of it, but the deputy commissioner and the circle officer.
A circle officer, he was working under the authority of the deputy commissioner, the authorizer. So you go for the mission flood free Guwahati project is there that we're doing. And he made a map. That's a map to which area will be evicted, which will be not evicted. Again, he saw a record says, my lord, 92 that was allotted to the petitioner. In 95, my lord, that was cancelled.
How?
The order is there.
That order has already been set aside.
That-
Those aspects doesn't come.
The
When
record
there
was
was
not
an order
corrected.
being passed by the court,
Yes, yes.
you could not have done anything to that effect.
Definitely, that is true, my lord. But that record
I
was
will, no, Mr. Today you are appearing for 2 and 3?
three only two.
3. Ask him to do something, settle it out with the petitioner, pay him 15, 25, 35 lakhs, whatever may be for the court. For them, this amount is meager.
No, my lord, he petitioner being a government official. He is working under the my lord, government.
Who?
That's point number 3. He's a
Ah.
circle officer. He's not personal my lord, capacity. He my lord, do it. He was doing it.
Then ask him to build the house.
No, my lord. That's why, my
Ask
lord,
him to build a house for him.
so that's why, my lord, I asked him to make the my lord, present deputy.
No,
Just a-
Mr. Jutia, why are you not understanding the simple question?
No, I
The
understand.
thing is, this is not a case of implementation. He's not asking for implementation of the order.
No,
He's asking for willful violation of this order.
No, I am, my lord, what happened, my lord? I am only praying because that to implement, my lord, so to give something to the petitioner, my lord, the deputy commissioner is necessary. The deputy commissioner.
Not
So,
necessary.
Who will move the
I
file?
am not
No,
concerned whether they pay or not. Here is a case of violation of that
yes.
person. In these proceedings, this court, he is not going to ask for that. The moment he does that, it would be amounting to implementation for which you may tomorrow say that his cause of action is different.
No, my lord,
Mr. Sudhir,
after-
I was also on the other side. Don't make this thing.
no, yes, yes.
I'll have this matter again on 16th of February. Give us a good concrete proposal what you are going to do with this petitioner. Otherwise, be ready to go to jail. Sending these people for jail for six months, I think, would compensate the petitioner.
And even the affidavit was filed after 7 years.
Yeah.
Repeatedly, the matter was
Nothing
miscarried.
doing.
But
This is a very
Affidavit
serious
was
thing.
not filed.
No, why delay? We have explained the delay. So he was transferred and he was made.
Not necessary. You, for the purpose of doing all these things, you can do everything. The circle officers, they do everything. The deputy commissioner does everything, breaking up somebody's houses out there, knowing fully where there is a court's order. Why should we follow court's order? I will better follow the government officials. That is your lookout.
No, my lord.
This is the thing.
No, my
Then
lord,
why?
actually, at that time of eviction, my lord, that eviction, he was not brought to the notice of this case.
No,
So
it's
he
not like
did
that.
not know.
Not
So
like
he
that.
did not know. He say affidavit in my lord also.
It is
He say
just
did not.
Why will he not? Why will he?
That was
My
These
building
these
was
things.
demolished.
First of all, your lawyer was very much present. When a government advocate is very much present, it is his duty or her duty to inform the authorities
Yes, sir,
that there is an order passed by this court.
that
My
was done.
building
And
was
then also
demolished.
you have
I'm
broken it.
supposed to show the stay order.
Yeah,
And for
yeah,
that, my building was demolished.
Uh,
I will not show my stay order.
Huh?
The stay order I'm having.
Somebody who is staying out there, this is the state of affairs.
My lord, to some other
Release the
person
matter
also there.
again on 16th of February 2024 for further hearing on the matter. Serious issues.
Obliged.
Yes.
I think for withdrawing of this case, might have this liberty, might have filed a revision.
Huh?
I'm withdrawing this case, madam. With the liberty, might have to file a revision petition.
Revision. Why?
Actually, my lord, the batch of cases around 12 to 14 cases were filed, my lord, out of 26.
What are these cases?
My lord, they're challenging the order of the district judge, my lord, under the PPI.
Under?
the public premises eviction of unauthorized.
So why do you want to file a 227?
My lord, in fact, the court said, my lord, there's an order, sorry, judgment, my lord, it says that another 58, my lord, that 226 is not maintained.
Don't worry, we'll convert it.
My lord, the order that
Tell me what is your
in
case.
fact, 8 to 9 cases they already withdrawn and revision petition has already been filed, my lord.
You have filed it.
Yes, my lord.
You want to withdraw?
My lord. Only 2 or 3 cases is left, my lord, they were not listed, my lord. The other cases are already withdrawn and filed a revision petition.
Liberty for what do you want?
To file a revision petition. Under 227.
Don't worry, we convert it. I tell you what. Why do you need to file it? Now tell me 227, we convert it. Now you tell me what is your case. What is wrong with the order?
My lord, actually, I have persons ready for it.
Huh?
Can it be there tomorrow?
Then? What is wrong? First show me that you are the owner of the land. Are you the owner of the land?
That's a railway land.
So then rightly pass the order. He dismisses on
Lord,
their own. Let us not go into the question of maintaining.
My lord, this petition has been filed by the railways.
Which one?
This 50.
You are the railways. Then you have a right.
My lord, we have
You convert it into 227 and allow your petition. Why you are aggrieved? You are making the estate officer a party. Your people.
my lord, actually, this petition was filed by Mr. Bhimal Sharma, my lord.
So you mean to say he didn't know the law?
So at that point, the
Then?
matter subsequently handed over to me, my lord. And thereafter, during the hearing,
No, why are you making the estate officer a party?
because he was also my lord, a petitioner.
And has the service of notice have been affected upon respond number 1? We have not taken steps. Huh? No steps taken. Yeah. You are not interested.
No, madam, we are
On
interested
many
in that.
occasions, the matter has come up before the Lozima court. You don't care to appear.
My lord, these cases were subsequently handed over to me, my lord. And thereafter, during the course of hearing, my lord, almost 8 cases they were withdrawn and press revision petitions has already been filed. But these cases, few cases, my lord, 2 or 3 of them are left and they have not been listed, my lord. So this is after very long time.
Okay. The learned counsel appearing on behalf of the petitioner. Because how do you take care of the limitation? There is no limitation 227. Okay. The learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the writ petition, taking into account the judgment of the Supreme Court in the case of Life Insurance Corporation of India versus Nandini J. Shah and others reported in 2000 AIR 2018 SC 1197. He further submits that he may be permitted to file a revision application under Article 227 of the Constitution. First, taking into account the submission, the instant writ petition stands closed on withdrawal. However, liberty is given to the petitioner to file file appropriate proceedings if so advised.
Much of that.
Yes.
Your Lordship, in this case, Lordship, respondent was transferred, Lordship. So,
You mentioned the matter
yes, Lordship.
in the morning.
Yes. Kindly give us 2 weeks time, Your Lordship, to file the impeachment petition for newly.
Huh? Why is the contempt matter becoming so thick, fat? Huh? Vishwajit Pegu, Pallab Jha. Then, what are you asking for? Compliance? How many times you are going to do it? What is the order?
My lord, at page 169.
Huh?
Page 169, my lord, is order against to contempt.
Page 159.
169. And the 11% is 170, my lord. Party portion is 130.
I don't have so many pages out here.
In contempt petition, page number 11, Lordship.
What is this page? This is the order. What is the order? You have joined together file a petition according to 15. Yes. Why haven't you paid? Who are you? Deputy Commissioner?
No, my lord, this.
Who is appearing for the Deputy Commissioner?
Mr. Dina appears, my lord, he's on election code number 7.
Okay, none appears. We asked the Deputy Commissioner to be present. Anyways, he's coming on 19. Na? When did I fix the matter? We have it, his personal appearance. We remove his advocate. I think that is a better source of effect.
He'll be here, but he's on election code 7.
Madam, you find out why the Deputy Commissioner has not paid the money. When did we fix the matter? No, in the other matter, 19-1. I fixed it on 12-1. I fixed it on 12-1. Let you know, for it was Deputy Commissioner to nothing. Was appearing.
Let Mr. Dina be present, my lord.
Not necessarily. Let him be personally present. If you don't have the lawyers out there, we don't require. He is not appearing. There are hundreds of lawyers who can appear. He can engage if he can't be only one lawyer out. What is this?
Let it be passed in his presence, my lord.
On 12, na? 12-1, na? List the matter on 12-1-2024. On which state the Mr. Dina, the learned senior government advocate, shall apprise this court as to why the order passed by this court dated 28-1-2019 in WPC number 4507/2013 has not yet been complied with. Full stop.
Okay.
Not in the question of these persons. I don't want whose appearance it is. We are not concerned. We are concerned out here as regards this person, why he has not got the money. How many times, every time you keep on changing the Deputy Commissioner, the petitioner is going to keep on amending? No. The directions have to be there, payment has to be made. Yes, who is appearing here?
For the sole respondent, I am appearing.
Ah.
In 2021 itself, my lord, a proposal was submitted to the government for necessary sanction. Thereafter, my lord, updated instructions I don't have.
Shall payment of fresh representation in the superintendent in India along with a copy of the order of the petitioner, whereafter the same shall pass an order which we pass. Yes, what have you passed the order?
My lord, this thing, my lord, they are submitting proposal, they are admitting the amount, my lord, 3,90,000. And they are submitting proposal to the government for sanctioning the amount for releasing to the petitioner.
When?
That is of my lord 2021.
Then?
Thereafter, my lord, this matter is also not listed, my lord. So updated instructions I can
Okay,
have.
I'll bring it to
Probably,
the
my lord,
list. List the
nobody's
matter on
affiliated
5th of
for the-
February 2021-24. On which state Mr. B. Gogoi, the learned counsel, appearing on behalf of the
sole respondent.
sole respondent. On which state Mr. B. Gogoi, the learned standing counsel of the PWD, as well as the learned counsel appearing on behalf of the sole respondent, shall apprise this court as to what is the status of payment of the dues to the petitioner.
Okay.
Yes.
One thing has been shown wrongly in the office. My name has been shown as petitioner is purchased, and his name has been shown as the legal aid counsel. I am the legal aid counsel.
Okay, anyway, very good. Now tell me, what is this? Why the matter has come up for orders? Because it's a contempt.
Yes, but I have order. I rejoined affidavit.
Now tell me, what is the order you are asking for compliance? Which order? The contempt petition is bigger than any. Why is such a big contempt petition? 62 pages.
My lord, Annexure C, page number 101. That order has been violated. The order passed in WA number 167 of 99.
No, no. Which order are you asking for compliance? Tell me.
That is, my lord, at page 169.
Huh?
Page 169. Sorry. Okay.
Yes. 13/8/2018.
Yes, yes. That is the only.
Yes. Then has this is the suit disposed of or not?
No.
So you are filing contempt because of that.
For that also,
And
they have violated all the orders.
what order?
Retable number 167 of 99 order was passed. That is not complied with. The name of the order, they have captured our house and
Who?
Tinsukia district. My lord, Annexure C, my lord.
No, no. Which order are you asking for? One is this one.
All
Being
the orders
brought
has
to
been
obtain
violated, my
absurd ex parte order. No, if there is an absurd ex parte order, then you need to approach the division bench for correction. But as regards the other matter, to issue direction to the contemners to remove the illegal and unauthorized construction on remand and to restore the petitioner's possession of the where is the direction for restoration of possession?
My lord, an order was passed in the retable. The Annexure C, page number 81, 102.
Page number?
Page number 81 to 108, 102, and 102 is the operative portion. Page number 102. One zero one, my lord, at the last.
Yes, you are appearing for who is appearing for whom? The private respondent?
I am appearing for 1 to 4, my lord.
1 to 4. And for who is appearing for 5, 6, 7?
I am appearing for
7. What about 5, 6? 8, 9, 10, 11?
I'm appearing for respondent number 8.
Why are you making the district and sessions as a party?
Because order was issued to the chicken also for equity disposal of the case.
Order was not issued to the judge. It was just case was transferred Mufti court for that party.
No, 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 don't make all these people a party. Then you are appearing for? You are a private respondent. Are you in possession of the land? And why the district administration have not taken any steps in pursuant to the division bench order?
At that time, my lord, actually, I was not a deputy commissioner.
No, but now?
Now also I am not there. In between, after this order, my lord, at page 170, I was deputy commissioner. At Tinsukia district. That time, my lord, this order was directed to Munsif to dispose of the matter.
No, Munsif is okay. But there is a direction by the division bench upon that the private respondents should vacate and give it to them.
Yes.
And the deputy commissioner and the circle officer was directed, the deputy commissioner and the district magistrate Tinsukia and the superintendent of police. Who is the superintendent of police?
That time, my lord, I was not there, so I have no knowledge about this order.
Now you have the knowledge.
Now also I am not there. In between, for 2 years, I was there. That time, no order was served on me. And I'm not aware of this
Order was
event.
already with the office of the deputy commissioner.
Office is different, Mr. Counsel. Here, that is why I'm saying. You see, when it is a contempt jurisdiction out here, you have that person. This is a quasi-criminal proceedings. And being a quasi-criminal proceedings, that person has to be addressed out there. So they have to know. Without they knowing it, how do I do it? But anyways, we still have Mr. A.K. Gupta to catch hold of. Yes, Mr. Gupta, why you are not following the court's order? Wouldn't this come under criminal contempt? Understood, but was the order passed by the division bench interfered by any other authority? By any appellate court forum? Was it interfered with? That to hand over the possession? Then? No. What do you say about that at page 102 of the division bench judgment? The private respondents, more particularly the respondent number 10, would remove the construction raised by him with the tube well therefrom. The district so-and-so, Tinsukia, and the superintendent of so-and-so would ensure that the above directions is carried out without fail. And further, here it is given, the suit maybe has been withdrawn, has been filed at the instance of Iman. In absence of well-articulated adjudication, no summary procedure is adopted, and that too in contravention of the orders of the court can be counted. In the wake of above, it is ordered that the respondent authorities will forthwith restore the appellant's possession in respect to the following land. Respondent authorities. Who are the respondent authorities? Then, who is Bhupendra Kumar Majumdar? So you were the appellant. So the order has come in your favor. Then order has been complied with. Then what do you have?
This order cannot be complied with. The land which stated here.
Mr. Kam, you want the matter to be adjudicated upon within 6 months. That's it, no? Let us now make it very simple. You are unnecessarily making it complicated. Who is appearing for we strike out the names of all these people unnecessarily. Why you made the district judge a party? List the matter again on 5th of February 2021, 24. The registry shall obtain instruction as regards the status of title suit number 20/2011 pending before the court of the Munsif number 1 at Tinsukia.
No, now it is in.
Huh?
Now again it is transferred from Margarita.
At Tinsukia. At Tinsukia, na?
Now it is.
Munsif number 1 at Tinsukia.
Like.
Yes.
The office of flow of party is not completed, Lordship.
Okay, service is complete.
Yes.
Leaves the matter for admission.
Yes.
in the second week of February.
Highly obliged.
It's a way.
Right, this case, Lozima court report shows that service complete. Lordship order was on pilot 29/9/20. And Lozima order is 9/11.
Taking into account order, taking into account the order dated 9/11/2023 passed by the Lozima Court. The service is deemed to be complete. So accordingly, let the matter be listed for admission in the second week of February.
Obliged.
Yes.
Steps are taken upon respondent 3 and 4. Officer told that this is complete.
Huh?
Notice
Service complete.
copies are served upon the respondent 3 and 4.
Okay, service is complete. So you are not filing a affidavit?
My lord, I am appearing for respondent 3.
Okay, you are filing affidavit?
No, my lord.
What is three? Three Hindustan Paper Corporation. And what is Silver Cat Private Limited?
Silver Cat primarily was a security agency upon whom the security service.
Who is going to make the payment to you?
3 and 4. So,
No,
the
4 is okay, but 4 will make it. But how do you effect against them? It is under still liquidation.
Yeah, he is for the liquidator.
Then what has happened now?
Now that property is with the hand of the
Then don't
now
you?
the new owner is there.
So are you not required to make the AIDC a party?
Just now I came to know that he is the liquidator.
It is glaringly out there in the big voting out there that AIDC is the owner of the property. Mister? It's the learned counsel appearing on behalf of the respondent number 3 submits that the insolvency proceeding so initiated against the respondent number 3 has been completed, and at present the property at present the Nagaon People Mill.
All
Huh?
the entire HPCL property. Nagaon and Kathal.
Nagaon and
No, the HPCL company, is it there or not?
For Assam,
HPCL has 2 more factories, 2 more mill at
HPCL
Kerala and Kerala and Mizoram.
No, that is the different thing. Yeah, the company still remains, but these properties do not.
company still remains.
Kerala and Mizoram, two.
Then in that regard, obviously HPCL can be burdened with only those 2 properties were demerged out of that of the company, isn't it? It's a case of a merger.
The company exists.
The company exists, so the company can be proceeded with. Unnecessary. You file your affidavit. The record reveals that no affidavits have been filed by the respondent authorities. Let's list the matter again on 23rd of February 2024. The respondents shall file their affidavit by 16th of February 2024. The petitioner thereafter would be at liberty to file their affidavit in reply if so advised.
Application for order 9 for restoration of that.
What is this? Restoration? Who passed the order? Where is that?
On the page 47. On non-prosecution, it was
Page?
47. No, 47.
None appears on behalf of the petitioner. It appears the earlier occasions had also none appeared, taking into account the witness is not interested in for which. Yes, tell me, who is the petitioner?
Lordship, petitioner lordship, earlier they engaged other set of advocate lordship. On 17 May lordship, we have filed.
What is the petition for?
Petition for non-payment of lordship.
How much?
59. 59.
Okay, 50,000 restoration.
Lordship. My lord, I have no objection. If I-
50,000?
I think that you go to my lord, he's already the petitioner, but it's already lost.
So what? Lost? Your petition is dismissed.
Only because of my fault, but I thought-
So therefore, I can also say that they can take out from the fees of Mr. Haloi.
No, no, it's 30%. On last two occasions, it's better was discussed.
I am not going to restore it without payment of cost.
Not to say that I had a, let's say, 30%.
Yes.
Last three occasions, it's better. But even the first list, our name is not good.
Show me. Whose name has been shown?
Name of
Where is the
earlier
matter?
set of advocates were shown, Lord.
Huh?
Earlier set of advocates.
Why?
Lord, the wakalat number, we have filed.
Wait. What is your what is the name of the case?
Goel, Lord.
Goel Foam.
Here, private.
Where is it? Goel Foam.
It's situated to Uttar Pradesh, Lord. Sorry.
A. Hassan J. Bhorali M. Day. This was shown on 7th of June 2023. When did you file the
We
wakalatnama?
filed on 17 May 2022, but it was lying in defective. That fact has come to our knowledge. No, no,
How?
That fact has come to our knowledge
Uh.
when the matter was listed twice
Uh.
and our name was not shown. We made an inquiry before the registry of,
Uh.
and therefore on 9/11/23, we made a application for the registry to list this matter on 28/11/23. However, Lordship, that was not listed on 28/11, it was listed on 18.
Uh.
And on that day also, Lordship, our name was. And on 18, Lordship, not listed, Lordship, by other budget. I was not voted for. I cannot not have it.
When was it dismissed for non-prosecution?
On 18/11.
Then,
On
why didn't you look into that?
On 18/11, Lordship, was Saturday, Lordship, and my mother was in ICU. DNR job.
How many people have filed the affidavit wakalatnama?
Lordship,
How many people? Then what were they doing? So cost of will reduce it.
Lordship,
Reduce it by 10,000.
no, not.
How much?
So far.
What? Let you go before the division bench.
Lordship, Lordship,
No, it is not a genuine case. Sorry. Cost is mandatory. Cost is mandatory.
Names were not shown.
So what?
How can
So
you
what?
to know that?
It was your wakalatnama was defective.
Therefore, Lordship, when we came,
It was your responsibility as a lawyer. Okay, we impose the cost upon you, not the client.
Lordship, when we came to know about
You
the-
go and file appeal.
No, Lord.
Okay.
Lordship, I think,
No, I'll impose cost upon you. Hello, you will.
Lordship, I have
50,000.
Lordship,
The instant application has been filed for restoration
names were not shown.
of the writ petition, which was dismissed for default by an order dated 18/11/2023. It has been submitted that on 17/5/2022, the wakalatnama was filed by the new set of councils. But there is no reason assigned as to why the wakalatnama remained defective. It is also apparent that on 3 occasions, the writ petition was listed before this court. And it was absolutely on account of the fault of the councils appearing on behalf on the councils who have undertaken to appear on behalf of the petitioner. Which had resulted in the order of dismissing the writ petition for default. Taking into account that it was the mistake of the councils, it would not be proper on the part of this court to penalize the petitioner. For which this court recalls the order dated 18/11/2023 and restores the writ petition to the file. This court further imposes a cost of rupees 50,000 upon Mr. M. Haloi to be deposited. But no, the fault is not that. On that day, understood on 1811. But what were you doing from 17/5/2022?
Because the matter was not listed.
Forget about matter. No. When you file your wakalatnama, isn't it your responsibility? Then, is this the manner of how many years of practice you have? And then also, is this the manner of taking taking control of a brief? Why will it the matter will reach unless you take care of your wakalatnama?
That fact has came to our knowledge.
Not that fact has come to your means. This is absolutely irresponsibility. I impose cost of 50,000 to be paid to your client by you. Because he has suffered. Not on them. Because of you. Next time, Red Book or Bhorai Dibo na. I did.
I have filed IF for implement of new incumbent in the office.
Huh?
I have filed the IF for implement.
Implement of whom?
Impleement of the Malad Nivedita Datta, who is the chairman of North Lakshmipur Municipal College.
Very well. Have you informed her?
Yes, but I have.
Where is that notice?
But I have submitted on the affidavit.
When?
The affidavit page number 10.
Where?
The affidavit I have filed, man. Python 12 and 20.
With reference, I would like to inform that Honorable Panel directed you to take necessary action that respondent against the response number 5 and 6 and a copy of the audit.
This is already received another tracking consignment report that page 12.
What?
It's sent by register post with other than this was received on 15/9/2020.
Hmm. Okay. The instant application has been filed by the petitioner to implead the present chairman of North Lakhimpur Municipal Board, North Lakhimpur, Srimati Nivedita Datta, as a correspondent to the accompanying contempt application. This court, upon perusal of the material on record, including the additional affidavit, including the affidavit so filed, is of the opinion that the said Nivedita Datta, the chairman, North Lakhimpur Municipal Board, having her office at North Lakhimpur, Assam, is required to be impleaded as the respondent number 2 to the accompanying contempt application. Accordingly, the petitioner is directed to file an amended memo of parties before the registry of this court by 5/1/2024, and on the basis of the instant order, along with the amended memo of parties, the registry shall make necessary changes in the cause title of the accompanying contempt application and update the same in the CIS. Issue notice. Returnable 6 data that returnable on 19th of February. Second one, steps be taken by way of registered as well. Issue notice to the newly impleaded respondent number 2. Steps be taken by way of registered as well as usual by 5/1/2024.
Okay.
Item 42. I'm sorry. The Lordship has directed me to apply in item 42. I could not appear. I was with the applicant.
I've asked, put your name only.
Look.
Apprise why you have not paid the money.
Look.
I'm not on the question of who is the deputy commissioner out there.
Look.
Forget about the deputy commissioner. These people keep on changing. But here is a question: when there is a direction out there for you, you have already taken 3 bigas. Why you have not paid the compensation?
I'll
You get the instruction on
Yes.
12-1.
Look.
But another aspect, another matter was there where I have fixed it on 12-1. That matter, I've asked the deputy commissioner to be personally present out here. In view of instruction being given by this court to get and direction being given by this court to obtain instructions, but he has not provided. The government advocate informs this court that they have not, in spite of the order being shown to the deputy commissioner, he has not given any instruction. I've recorded those aspects. I've asked him to be personally present at to video link and 10:15. He need not come. 10:15 to hear as to what has happened. And if he fails at 2 o'clock to be present.
I'll pick up.